Rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right is Justice Henry. To my left, Justice Walsh. And we will be hearing maybe 6 cases this morning, or this morning and this afternoon in all likelihood. Our rules are as they always are, which is 15 minutes per side. If you are dividing your time on one side, which obviously is not happening in this case, you should let us know at the outset how you intend to divide your time. There is no rebuttal. We are familiar, sometimes overly familiar, with the facts of each case, so you may want to begin with your argument, but of course it is your time and you may do with it as you wish. The first case we will hear today is Commonwealth versus HRAIZ, which I may be mispronouncing, and we will hear first from Attorney Sheketoff.
Good morning. If it pleases the court, Robert Sheketoff for Joseph HRAIZ. Said it right. The prosecutor argued in his closing argument, reiterating the charge that the judge gave because it was a bifurcated charge. She talked about the elements first. Quote, the Commonwealth's burden is to prove that she submitted because she was afraid, implied force. It's not a theory. This is an instruction in the law. So my basic thesis this morning is that implied force cannot be defined simply by its impact on the state of mind of an alleged victim, that it has to have some objective component to it, or it takes force completely out of the rape statute.
So, Attorney Sheketoff, if the person here just absolutely froze, how could your client or hypothetical defendant accomplish the sexual act without the use of force? Even if it was completely unreasonable for them to freeze. But they did. They just absolutely went catatonic.
Well, because the act of penetration itself is not considered sufficient force.
Well, but but the person is not responding and the hypothetical defendant has to undress them, position their body. How is that not force under our case law?
Well, it could be done extremely gently so that one would say that there's no force involved at all.
Well, if she were unconscious, we would say force was involved regardless of how gentle it was. So I think Justice Henry's question is, if someone starts asleep and then feigns continuing being asleep, is that amount of force still force?
So I would say no, because first of all, a conviction cannot be affirmed on a theory that was not presented to the jury. And this theory was not presented to the jury, that she was in fact the equivalent of asleep because she was frozen in fear. But I think the question really goes back to my main thesis, which is there some objective component to constructive force? In other words, if this...
So can I interrupt for a moment? And we all have read your briefs, and I have to say at first, when I was reading your brief, I actually thought it made quite a bit of sense that subjectivity in criminal cases of this nature didn't seem to necessarily fit. But then when I started to research, first of all, you use the word implied force. The case law uses constructive, right?
That's the phrase the judge used at trial. But I think it's exactly the same thing.
So I note that you don't have any cases to support your position that there is an element of objectivity of fear. And I think there's a reason why you don't have a case to support this position.
So,
We would be creating new case law, in other words,
So-
by creating an element that otherwise doesn't exist. Would you agree?
not exactly. So
So
when...
tell me a case that supports your position.
No, I don't have a case that's directly addressed this issue, Your Honor. But when this court, for instance, decides whether or not my motion for required finding of not guilty should have been allowed, does this court say, well, the alleged victim says that she was in fear, and therefore that's all that we need to prove for constructive force? Once she, because it has to be looked at...
So the constructive force theory, though, you would agree with me, is different than the threat of harm, right? So there's physical force, there's constructive force, and there's the implied threat of harm. So someone who puts a gun to somebody's head and says, if you don't submit, then I'm going to kill you, right? That's rape. Somebody who physically attacks a person against their will, that's rape. Constructive force is in the brain, right? It's overpowering the will, right? It's through the idea of whether it's intimidation, whether it's that type of kind of fear upstairs and overpowering.
I understand your point, Your Honor, but what I'm saying is, how could this court ever say when a because if I take your position and you look at, on appeal, you look at the evidence in the light most favorable to the Commonwealth on a required finding issue, how could this court ever say that a victim who says, I was afraid, was not the victim of constructive force?
Armstrong says in that case the victim was not afraid. She testified that she was abused and that she was not afraid, and that didn't matter. That was a constructive force case. Secondly, would you agree with me? The Commonwealth argued actual and constructive force to the jury. I mean, how does this case not succeed on a light most favorable to the Commonwealth on actual force?
So the Commonwealth did not argue actual force to the jury. They specifically argued implied force and nothing else. And they agreed to that during the charge conference and all along.
Weren't they instructed on both?
The judge instructed on every theory of force that there is. I'm not saying, I didn't say...
Did you object to any of those instructions? I know you asked for a reasonableness instruction, but did you object to the inclusion of theories that were not?
So I wasn't trial counsel, but...
Well, did defense?
I understand, Your Honor. Trial counsel saved his rights on not charging on reasonableness. But Justice Walsh, I'm not saying, what I'm saying is if an alleged victim says that she was afraid, is that constructive force as a matter of law? I'm not saying you can't find constructive force when she doesn't claim she was afraid, but if there's no objective component, then, for instance, let's say this alleged victim was afraid of red shirts, and my client wore a red shirt to bed, and she was actually and honestly afraid and frozen because he was wearing a red shirt. Would this court affirm on appeal a motion for required finding of not guilty? And if the answer to that is no, then the mere fact of her being afraid is not sufficient. There has to be some...
What I'm suggesting to you in constructive force, fear is not the element that we look at. Constructive force is whether the person's will was overborne. And so the judge, I would suggest, using the model jury instructions, properly instructed, is the argument that I want to hear from you of why this argument doesn't hold water, that you look at the difference in power, you look at the, sometimes the age difference, the weight difference, and you can say the jury got it wrong. This was not actual or constructive force, but when I look at that jury instruction, fear, I would suggest to you, is the wrong analysis. It's the being overborne and the will being overborne. And so those factors that the judge instructed on are talking about that. And that's why Armstrong says it doesn't matter that the victim said she wasn't afraid, because fear is not the essential element. In essence, you'd be asking us to include another element, which is reasonable fear. And I've looked at the cases, counsel, and I can't find one that adds that element to constructive force.
And my rejoinder to, I agree with Your Honor. If there was a case, I would have cited it to you. But my rejoinder to that is no one has saved their rights on this issue because the evidence in this case is so thin. Most of the time, whether there was constructive force, actual force, or threats, it's painfully obvious, and no one's defending on the grounds that there was not force.
Is an implied threat different from constructive force?
So I think all these things sort of bleed into each other.
Well, they don't all, right? Because physical force isn't the same as constructive force.
But the constructive force instruction says it has implied threat language in it. And this is what the judge charged to the jury. And what I'm arguing to you now is that this is a jury, this dilutes the burden of proof to establish that Mr. RAIZ used implied force, or, which is the phrase she used. The Commonwealth must prove that the victim submitted to the sexual intercourse because she was afraid or intimidated by his words, gestures, or actions. That's at page 25 of the charge. So when this court, and this court does, and this court has in the past, reversed convictions for rape on required finding issues, what substance, what is there in the constructive force language that has some meaning other than its impact on the alleged victim's mind? Is a red shirt enough if she was honestly and in fear based on a red shirt? Would that be enough, or would this court reverse? And looking at the evidence in the light most favorable to the prosecution, as it must, this court would say, well, she testified she was intimidated. She testified that she was afraid, and that's why she submitted.
Right, but here, and to use your red shirt example, she testified that she froze. And
Right.
so if she froze, even if he's gentle, but he's doing everything that needs to be done to accomplish the act, how is that not use of force under our case law?
Okay, so, Your Honor, I see your point on the required finding issue, but what I'm arguing now is the charge issue. In other words, the jury doesn't have to believe every word that comes out of her mouth. Even if they generally believe her, they can believe some, all, or none of what she has to say. And unless they're properly instructed that he did something that would make a reasonable person or a rational person afraid.
Sherry seems to say something about reasonableness. Can you talk about what that case stands for?
Sherry?
Yes.
Yeah. So I cited in my
Yes.
In my brief. It's not totally on point, but I think it gives me some support.
Well, it does, and unfortunately, the Commonwealth chose not to respond to your argument,
Which I'm sure we'll ask the Commonwealth about, but go ahead.
So, you know, I think of, as an analogy, self-defense, where you must subjectively be afraid or in fear of death or serious bodily harm. But there's some objective component to that, too. It's not enough for me to say I was afraid of this person, he was wearing a red shirt, so I shot him. You have to, there has to be some objective component to this, some way to measure whether what was done, because the test in all the circumstances, I mean, this is a test, a balancing test of some sort that is so wide open it means nothing. Look at their sizes, look at their relationship, look at the...
So you're saying that the jury had to be instructed that they had to find her fear, her freezing was objectively valid?
Yeah.
Well, reasonable.
Or reasonable, not, in other words, that her subjective state of mind is not sufficient to meet the burden.
But the burden isn't a both. It's either the victim was afraid or that the victim was intimidated by the defendant's conduct. And so I still want to hear of why this isn't an actual force case, because it seems to me that there certainly was an argument, and it seems to me that it doesn't have to be all under one potential bucket, right? It doesn't have to be all actual force. It can be actual force and constructive force.
I agree with
right?
that.
So when the jury considers the physical actions of your client, I don't understand how the road doesn't end there.
Because force is the main thing that separates criminal sex from what
Okay,
people
but
engage.
I'm still stuck on Justice Henry's question, and I'm not sure how this works. We know that consent is a question of fact. I know it's a separate element. It's a question of fact. There's no mistake of anything on the part of the defendant.
Correct.
Force clearly has to be the intentional something, right? Because it's you have to use force to accomplish your result. Now, and you're out of time, but if you don't mind, I'm going to finish my question. Now, Justice Henry suggested that someone who is immobile, any sexual contact, I don't know if she would say any, but sexual contact like this with an immobile person is by force. And you seem to be saying, no, unless the immobilization is caused by reasonable fear, it's not. And I'm sort of sympathetic to both halves of this argument. Can a person who is non-responsive or immobile, let's not say immobile, if someone perpetrates a sexual contact with them, is that by force or not by force?
So if you're immobile,
Not unconscious, fully, but just frozen.
if you're immobile by reason of incapacity, it's...
Okay, how about if
that-
it's by reason of unreasonable fear, but you're still just lying there?
Yeah, so I think that becomes a jury question, whether or not he intended to cause that.
Okay, you don't complain about the absence of a scienter. I mean, this instruction is ridiculous, and I'll ask the Commonwealth about different sentences in it, but it doesn't mention scienter. It doesn't say it has to be his intentional.
Well,
It doesn't-
actually, the case law is you don't have to intend to have illegal sex. You just have to intend to have
Well,
sex.
I think you have to
circumstances.
intend to put the person in fear.
Yeah, no, I
Don't-
just think there has to be some objective component to the word force. It can't be defined simply by the impact on the alleged victim, because if she's telling the truth that it had an impact of intimidation and fear, then as a matter of law, no matter what he did, whether he just wore a red shirt or anything else, he would have committed rape. Thank you.
I did have one quick question for you. Do you agree that in the light most favorable to the Commonwealth for purposes of the sufficiency argument, that evidence was that the victim had not consented to sexual contact?
Yes, she said she didn't consent.
Can I ask you another question? I know your time is up. I want to use a hypothetical, and I don't want to be inflammatory. You doubtless recall what former President Trump said on an audio tape that was revealed prior to his first election about a way that he would interact with some women, true or not. Would that act be by force if you just grabbed someone?
That's a tough one. My legal position would have to be, it depends on how you did it in the circumstances.
But that's a conscious person. They're not unconscious. And out of the blue, someone does something that would be a crime if it were done by force.
Right. So that's an indecent A and B. And he was convicted in this case of indecent A and B. I'm not arguing, I have argued nothing on indecent A and B. I would say that what President Trump said he did would be an indecent A and B and not a rape.
Okay, but I understand, but
And
let's
you
say
don't
someone
need-
grabbed someone because they were lying in bed together, and so it wasn't merely an indecent A and B, it would be some form of rape if it was done by force. The person is conscious, and the alleged perpetrator simply grabs her.
So it would depend on whether or not the amount of force used was, in my view, reasonable to create intimidation or fear.
It doesn't have any time for intimidation or fear. You don't even realize it's about to happen. And then it does. Force or not force?
Depends on the amount of, it depends on how it's done. I mean, you can touch someone lovingly in an inappropriate way and...
Well, it might still be rape.
I'm sorry?
You might think it's loving, but it might still be rape. Right?
So, yeah, I've been doing this for, May will be 50 years. I've seen the pendulum swing from, what I consider to be complete insanity, where a defense lawyer would stand up and say to a judge, it's his girlfriend on a bail argument, no matter how badly she was beaten up. And that was you could actually say that out loud, to something where we're at now, where, the line between young people engaging in sexual exploration and rape may have disappeared completely.
But this isn't that case.
Thank you. We will hear from the Commonwealth now from Attorney McGowan.
Good morning. May it please the Court. AD David McGowan for the Commonwealth. I can start right with Your Honor's hypothetical. If there was penetration with what former President and soon-to-be current President Trump did, that's rape. It's penetration without consent. That's what our case law boils
By
down to.
force. Of course it's without consent, but it has to be by force also.
But the penetration, in my reading of the case law, and there is not a case that says this either, which is unhelpful, maybe this could be the opportunity, but where there is penetration without consent, there's inherent force. That's rape.
You've eliminated the second element that the higher court keeps telling us is a separate element, so that can't be right?
That's what
The case law says about it's sufficient of the act itself, right?
If the person's unconscious, is all the case law says so far.
Exactly. And I fully agree with the court. There isn't a case that dispenses with the force element. I'm not suggesting the court dispense with an element in any way. But as the case law unfolds, reviewing various factual scenarios, predominantly under the constructive force cases, this is what ultimately ends up being the conclusion I draw from the body of the case law, is that if there's penetration without consent, how can it not be rape? And what we have here is both actual and constructive, but the nub of the interesting issue raised by my brother is what...
Well, okay, some of us have sons, and that is problematic, because if they are fooling around and then she freezes and he doesn't notice, which is quite unfortunately common, and there's now scientific studies that say sometimes people freeze, he could engage in penetration and she will feel raped and he won't know that he's engaging in force because he doesn't realize she's frozen.
I'm sympathetic. I'm a man myself. I was a youth. I don't have sons. I have daughters. But that's still problematic.
I'm going to go out on a limb and say it doesn't matter what kind of children anyone has. These are legal questions.
Well, but the law of I would be very happy if the legislature changed the law to say that affirmative consent is not required, but that seems to be, but that's not our law. One could argue that Mr. Sheketoff is right, that that's perhaps crazy, but it's not our law. And so what you just described makes affirmative consent required, which seems to me would be, do you agree that would be a change in the law?
No. I think the Commonwealth has a burden to prove lack of consent. And there's these cases, I've tried a number of them in the sexual assault unit. These cases are very difficult to prove. As Mr. Sheketoff mentioned,
You've proven lack of consent. It's not contested.
I was going to Justice Henry's question. It's not contested here, but in terms of the dynamic that, and the hypothetical and the concern that Justice Henry raised, jurors are vetting these claims all the time, and these are very difficult cases. And I think there's a survivorship bias in some respect to the cases that come before this court because they ended up in a conviction. That's all to my point. And I'm sorry, what's the bias?
Because it ended up here, what?
A survival bias. This court doesn't review acquittals.
Right, that is.
That's all. That's what I mean by that. Now, I'm not suggesting to get rid of force, but to put an objectively reasonable component. First, it's adding an element that similarly is not part of the law and hasn't been ever. But to add that component is, I think, incredibly problematic. It is asking to review survivors in a way that they can't defend themselves. Right, in this case, we have someone who is frozen, not incapacitated, so we're not under that clear element of the case law with the force is sufficient. But in this case, might as well have been immobile, frozen, there was no cooperation, there was no reciprocity at all.
But you've argued only constructive force before the jury, right?
That's not how I read the closing.
Yeah,
and
I'm just looking at the closing now.
Well,
But
I mean,
go ahead.
he just argued that right here to us, so do you disagree with that?
What the prosecutor argued when marshaled the facts, did he say this is actual and this is constructive? No. And I think there's a colorable reading of the closing that supports Mr. Sheketoff's argument. I'm not saying he was uncandid to the tribunal. What I'm saying is the way I read that case and the way these facts unfold is this began as an indecent assault and battery from a sleeping victim. So this began as an actual force with the painful pinching of nipples. So this began as actual force and that continued through. So then she was awoken. Now the incapacitation instruction applied and was given in this case with respect to the indecent assault and battery. The prosecutor did not ask that that instruction continue because he shouldn't have, and he was right not to because she was now awake. She was not under the influence of drugs or alcohol such that her will would be overborne. That dynamic in the case, the instruction would no longer have been appropriate. But that chronology of facts is incredibly important as the assault continues into rape. He begins...
Well, she says she was still drunk. Does that matter?
The way it was presented and argued not sufficiently drunk that it would fall under some of the cases where someone is, as the cases describe it, incapacitated. And the defendant knew or should have known of such incapacitation. I think this, to the degree alcohol played a role in it, it set up the context of the dynamic, which doesn't really fall into any particular elements, but as this court has described in Testa, looking at the whole context of how the event unfolds is part of the jury's analysis and part of the court's review on a sufficiency basis.
So I am concerned that, and I don't recommend this as a briefing strategy, that he cites this Commonwealth versus Sherry for the proposition that the defendant's words and conduct must engender a fear that is reasonable in the circumstances, so that it was reasonable for the complainant not to resist. And when you look at Sherry, it describes a jury instruction, and this was written in 1982. So not thrilled with the language, but going to the arc of the cases, it says that the man has to have this purpose of having sexual intercourse against her will, or by threats or bodily harm inferred or expressed. And then it says, which engendered fear, quote, reasonable in the circumstances, ... so that it was reasonable for her not to resist. So, but you don't address this case.
I don't, and frankly, I missed it. And
Okay.
I
Well,
will
because
look at it, and if a 16L is appropriate here, I wouldn't, but I would
But
submit
the
one.
Supreme Judicial Court picks it back up again in Felix F., which is not a rape case, so always dangerous when we start analogizing. But, I mean, this is Judge Hines, so very different from 1982. And she says, for purposes of the rape statute, quote, "threats of bodily harm may be expressed or implied," and I'm quoting, "so long as it is reasonable in the circumstances for the complainant to be in fear and not resist." So that sounds like, you know, and I found one other case which gets cited in here, I don't have it in front of me, but Commonwealth versus Chow also picks up on this. So we've at least 3 cases that say this. So what are we supposed to do with that?
Well, the court in Caracola also analogizes to armed robbery, where someone's saying, I was afraid of my life when the robber ran off with, I believe it was a purse. That was sufficient, and that wasn't didn't evaluate whether reasonableness of it. So it appears that there's 2 different areas of focusing on the quality of the fear, what the threat is. And here, I'm not suggesting, I don't think the facts support a theory of threats here, but to answer Your Honor's question, threats could be laughable. I will tickle you severely with this feather if you don't submit to my advances. That is unreasonable. Forcing oneself.
Wait a minute. So that would not be rape?
I think if a jury convicts and this court's reviewing on sufficiency, I believe it can be. If
Threatening someone with something nonsensical, consent, I'm never going to watch another episode of Seinfeld.
well,
Let me just,
Yeah,
what I
want
think
to,
is-
excuse me, I want to hear apparent reason became afraid to do something inconsequential.
can't imagine a jury doing that.
I didn't
I would
ask
imagine
you
there'd have to
that.
be.
I'm asking if that is sufficient.
It would depend on more of the victim's testimony.
So the victim says, I was in fear.
I think
period.
I think.
So
think
you
the
think
case law supports
fear,
that.
unreasonable fear, means force was applied?
I think lack of consent with fear
Yes?
is rape.
So it has nothing to do with the perpetrator. It's all internal. I didn't consent. We agree that's not an objective standard. It's just a fact that you can deduce from the victim's testimony alone, and that's unlike other jurisdictions, but that seems fine. That seems like a great thing. But now you're saying, and if you were afraid for no reason, it's also rape? I don't follow that.
The case law, as I read it, is a subjective test, and it has been for quite some while. And I recognize Justice Henry's pointing out that there's some case law that suggests maybe reasonableness is at play here. And of course, that's for this panel to decide where that falls. But the model instruction that's been used for a while is a subjective test. Under that subjective test, the jury is evaluating the evidence. As my brother said, it's a question of fact for the fact finder to determine whether or not that fear existed, whether consent was absent, and of the fear, was that a product of what the defendant did? Okay? It can't be a fear of it's a full moon and I'm going to submit to the defendant. It has to be something based on the defendant's actions or words or combination. When there is lack of consent and the jury finds that fear existed and it was the defendant's fault or his generation, I think the elements are met, regardless of whether we're wild about how we feel about the factual scenario. As this court has seen, there's a number of different rape fact patterns that are on the border of tremendously horrible. I think Testa was one of those terrible facts, to this case that may not be quite as close to that on the spectrum.
Right, so where am I misunderstanding? Because the way that I read it, you have 2 elements. One is to prove the act of penetration or sex, right?
Correct.
And the second is that the defendant compelled the victim by force. That force can be actual, that force can be constructive, or threat by force.
Correct.
Right? So the threat by force, I actually agree with Justice Rubin, and I understand you have your appellate hat on and the sufficiency of the evidence and blah, 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 but the threat of force considers whether that force is reasonable or not, because it's a threat. And those threat cases tell us that under this analysis, sure. And I think Attorney Sheketoff's example of the red shirt is perfect. That's threat of force. It would be unreasonable for a person to believe that a red shirt would cause somebody to be threatened to have sex. But force is constructive and it's actual. And this case does not seem to be a bit about threat of force. This case is either actual or constructive, and it lives or dies in the actual or constructive world, which is the physical force necessary to do the act, or the alternative, which is the power over the brain, the intimidation, the fear.
I agree with Your Honor completely, and I think to modify my statements earlier, I think under a threat of force cases, of which this is not, I think looking at the reasonableness of the victim and how they respond to that force is appropriate. And
Tell me what the constructive force is that isn't a threat of further violence.
Well, here there isn't a threat, do this or else.
No, it's not articulated as a threat, but where is the, if you're saying this is an actual force case, okay, I don't know, I'll have to look and see if that's argued. I think maybe it is an actual force case. But as a constructive force case, tell me what it is that, I mean, it seems to me that if the victim is in fear, she's in fear of something. What?
She's woken up from her sleep.
I agree with that.
To in the middle of it happening, sexual assault.
Yes, there's absolutely force. There's no question that there's force used in the sexual assault.
So it's with someone that she has been an undergrad with for a period of years.
Yeah.
And none of their friend group has had a relationship with this defendant in any way that was romantic or would have thought this could.
No, I get it. It's force and it's unwanted and it's out of the blue, apparently, and right?
And painful.
And painful, I agree. And so now, though, you're not saying, if it's constructive, if you say to me, and the course of conduct of that force, another forceful thing he did was penetration, digital penetration or oral penetration in this case.
Moved her clothing and undressed her while she was asleep, apparently, by lifting her shirt, and then lowering her shorts.
That's actual force. And I'm not saying it's not, but I'm trying to figure out if it's constructive force.
I guess I don't look at these cases as needing to fall into one or the other bucket. I think they can fall into both buckets quite easily. The same as circumstantial and direct evidence can be evaluated by the jury, some here, a little there. As long as they find proof beyond a reasonable doubt, we're fine. And that's what happened here.
I don't think this is like circumstantial and direct evidence. It's force, actual or constructive. Are you saying they're the same thing? I don't understand.
I'm absolutely not saying the same thing. I'm saying they can both be present, and the jury can find one or the other or both.
But I asked you, what is the constructive force? It's fear of further painful conduct, fear of further assault. I mean, that's why I think it's like a threat. It's that something further will happen to her.
I'm hearing fear and threat as different, right? So, but I can also see how they could be viewed the same depending on your position. So if that, I think maybe we're at an impasse. Her fear, in this case, is the continued sexual assault. She woke up, oh my God, what is going on? I am frozen, I am terrified, this hurts. And then it hurts more, and then it feels like it's going on forever. That's, to me, constructive force all day.
Well, that sounds like actual force.
Well, I also argue that, and I think the prosecutor argued that, maybe not on the nose, but I think that was also put before the jury, and they could have found on either, and that's why the judge gave the two instructions. I don't see it as a threat of force element. If this court does, that's an equally valid ground to affirm this conviction, and I do think the threat of force is substantiated by the evidence, but I see the threat more classically as something overt that's threatening. Do this, some kind of or else dynamic in all its different permutations is how I think of those dynamics.
So you'd said that this instruction contains the subjective fear. And I'm looking at your brief at pages 22 to 23. What language are you referring to? Is that is it the bolded language, or is it other language that you mean?
Well, I think I did the whole block quote with intention, but I bolded the ones that show what the Commonwealth's burden was to do, that she submitted because she was afraid.
All right. Okay, and then this may be more of a comment, but you described the Commonwealth versus PARRY cases holding that the physical force element of rape was satisfied by the defendant nudging the victim to the floor, removing her clothes, and penetration. And I do want to caution you that I don't think that's a fair description of the case. If you keep reading, the paragraph says she was saying no and telling him to stop. And I don't just trust my view, so I searched the case to see how this court has subsequently summarized that case, and in every single summation, which is only a couple, we've noted the saying no.
Then that is entirely my mistake. There was no saying no here at all. There is no, she didn't say anything, he didn't say anything.
Right. So
to the degree that the Commonwealth is not relying on FIRE in any way, either correctly or incorrectly, with respect to statements and red lights, green lights in any way, shape, or form. The Commonwealth is merely asking this court to affirm the 2 convictions of rape that are being challenged on appeal.
So just one more question. If our law is not that the affirmative consent is required, right?
Indeed.
And basically what you're saying, though, is if someone freezes, reasonable or not, but they just freeze, that's essentially going to be rape. If there's then a sex act, that's rape as a matter of law. Is there somewhere in between where it wouldn't be?
Well, I think practically speaking, if a jury were to find that and it comes to this court, my answer is yes. But jurors are vetting that dynamic every day throughout the Commonwealth in our courts. And these are really difficult cases. And frequently, they don't lead in convictions. And rightly or wrongly, based on the evidence. And so I do think part of the challenge here is the survivorship bias of the cases that come to the court are generally strong. And it feels like to me at the appellate level that the Commonwealth is winning these all the time, and this is a problem. There's a potential for a parade of horribles of almost what Mr. Sheketoff, I'm paraphrasing, these accidents, these kids learning about adulthood and adult relations. My reading of the case law is that it's a pretty low threshold with these two, with actual and constructive, and that's the law. It's up to this panel to modify it, or the general court to modify their statute. But as I'm reading it, I think that's a fair reading, that without consent.
Yeah, I don't want to classify this as exploration or whatever. There's a plain sexual assault at the beginning of this.
I'm not. I was characterizing that.
I was characterizing that is completely clear. The question, though, is for us is this somewhat tricky one. Although, as I say, I think it's easier to make the actual force case in this case. But
reading these, I know I'm over my time. Reading these cases, it does become a little frustrating and tricky to line up what is the correct path to perfection here. And I wish it wasn't as tricky. I wish this was a little clearer, but of course these are fact determinative. And to be clear, I was paraphrasing my brother, and I think this is a valid conviction. I think the jury did the right thing, and I'm asking this court to affirm those convictions.
Anything else from anyone else? Thank you for both for taking the extra time. Very helpful arguments for us, and a very terrible case as well. Our next case is number 23934, and this is, it is partially impounded, and I don't know if that includes the name of the individual. It does include the name of the individual? No.
Yes.
It does? So
it does.
We'll say Commonwealth versus an individual.
His name was Perry. Yeah, nothing was impounded to my knowledge.
We will hear first from Attorney Burkholder.
Good morning, Your Honors. May it please the Court, Fred Burkholder on behalf of Kenneth Perry. You read our briefs. I think they set forth the issues fairly clearly. I just want to highlight a few things. You know, I see a fair number of these cases, and the ones that I see vary in severity, but usually are all fairly extreme. This one is not. Part of it, of course, has to do with the motion in limine that was granted and the ruling that, you know, the references to the additional misconduct couldn't be included within both the testimony as well as the report. So that's what the jury saw.
Yeah, I wanted to, can I just pause you on that for a moment? I
Please.
was a little confused as to the state of the record on the criminal charges of which the defendant was not convicted. So is the Commonwealth correct that those records were provided to the expert witnesses, but there was no testimony before the jury and the expert reports were redacted?
Yes. Frankly, of all the parts of this type of case law that confuses me the most, it's that. Because Marquardt says you can't include anything that's not a conviction. It's got to be excluded, and that was the basis for the redactions. Then Mazzarino says under 14C, it all comes in.
Yeah.
And then you read, for instance, in this case where you have Dr. Bell, who initially says he's sexually dangerous and then says he isn't. In his initial report, he references the two additional misconducts, and in his subsequent opinion, he does not. So, assuming that we have to look at them because that's the law, it's still not the kind of case that is overwhelming. And I guess I directed something that it hit me this morning getting ready, and that was the reason why Dr. Bell changed his opinion. I have tremendous respect for Dr. Bell. I read a ton of his reports. Usually they're not favorable to me, and this one happens to be. And why did he change his mind? He changed his mind because he said in the initial report that Mr. Perry has little insight into his deviant sexual interest and sexual offending, namely managing sexual urges in the community. His contradictory statements and either denial or unwillingness to acknowledge his sexual attraction to boys and men are considerable impediments. Then he says in his new report, which resulted in a not dangerousness opinion, that he's demonstrated increased insight into his casual offending and readily acknowledged past inaccurate statements he's made due to his denial and lack of insight. And what that doesn't say is he also acknowledged that he was bisexual. So now all of a sudden, the impediment for his recognition of what all the treatment's designed to do is to identify what the problem is and try to find a cause for it, has been eliminated. Here's my other problem with this case, and I'm not going to go on forever because I know you folks have all day full of cases. Dr. Peretti makes some statements that trouble me. It is possible that sexual preoccupation applies, and within treatment there would be a lot more information to be able to assess that. This isn't a fishing expedition. It's whether the evidence is there or not. Dr. Peretti concluded the totality of the evidence is supportive of a sustained interest in pubescent males. What? Doesn't say.
But if you were to read the record in the light most favorable to the Commonwealth, you wouldn't include those ones, would you? You'd include, and that's the lens that we review. And I am not unsympathetic to your work as an attorney because I think the challenge is tremendous. To leave in the jury's hands a case of any of this nature, right?
Well, this guy, I mean...
But on appellate review, right, I don't disagree. In your world, this is one of the least extreme cases. In a juror's world, who are the fact finders here, they don't have your breadth of experience and knowledge. And so I'm not unsympathetic to that, but in the light most favorable to the Commonwealth, they heard from one expert who disagreed with 2 or 3 other opinions. Sufficiency of the evidence.
But the test is, in your world, our world today, whether the testimony was so incredible, insubstantial, or otherwise of such quality that no reasonable person would rely upon it. Now, I
That's a tough
struggled.
one for, I mean, this is an expert.
That's Blanchard.
And-
That's the
I
directive
understand,
evidence.
but I'm saying showing that an expert's opinion is insubstantial is a lift, right? I mean, in particular, there's this diagnosis of pedophilia shared with one of the, maybe it's Bell, one of the other examiners who concludes, I don't want to say examiner because they're not all qualified examiners, one of the other experts who says not sexually dangerous, but they both say pedophilia. And that's sort of the bedrock basis, I take it, of Peretti's conclusions, right? This is someone who has this condition.
Can I
Yeah,
say something?
please.
But shouldn't even be the way that it is. The reports indicate what and I understand the difference between diagnostic criteria and statutory criteria. Under DSM-3, you've got to have a 6-month pattern, all right?
I think we're at DSM, wait, we're at DSM 6, aren't 5 or 6?
Well, this one was 5,
Okay,
as I recall.
okay.
Under HRAIZ, a case very similar to this, there wasn't the 6-month, but the court took a position that you could look at the multitude of the evidence. So I know I'm up against that. That's the same scenario that we have here. So then we have to look at, basically, if we're going to look at, as Dr. Peretti says, we have to look at basically everything. Let's look who we have. The guy's never had a criminal record. He's been married twice. Sure, the offenses occurred while he was married. He was employed. He got a high school diploma. He has a resource plan that's in existence that's fairly reasonable. It's got some alternatives in it, but I think that's likely when you're in a situation where your family has illness within it and the like. And he's done every bit of treatment that he can. Now, sure, he took his time. While he was in custody, he could have went right on to MTC. He didn't do that. Then when he was initially found to be probable cause, he didn't jump right in. But when he did jump in, he's done really well. He's now a peer aide. He's now doing a security position in the institution. I guess my point I'm
Can I
trying
ask
to
you a
make...
question about the 6 months?
Yes.
Okay. If we had in the record the prior information about prior sexual acts that apparently is excluded, we might say 6 months.
I don't think so. They're not, then the next question becomes, do we aggregate or do we say over a 6-month period? And I don't know the answer to that, and I've never seen anything that tells me.
Let's, and that's because how far apart are the offenses?
Well, one was in 2012, December 2002, one was dismissed, and the other one was 2010.
That sounds like 8 years. That's more than the 6 months.
But that's when the offenses came to light and were addressed.
But here's my question.
That's not when they occurred.
Now we have an expert report. I don't understand this. The expert report is based on those facts. Redacting them from the report doesn't redact them from the mind of the person who wrote the sentence, sexually dangerous. So are you saying that report shouldn't have come in because it was based on inadmissible evidence?
No.
Or why not? I don't
Can't
understand.
win that argument because it's been up and down. It's statutory and it's been addressed by Mazzarino. It's been addressed Mazzarino. It's been addressed by Markert. I mean, it's there. It's been challenged so many times that far better
And the
lawyers than I
reason
took
it
a
comes
shot
in
at
is
it.
because of evidentiary rules about reports can rely on inadmissible evidence in order to,
Statutory.
oh, it's statutory.
14C says anything that can basically come in, and then Mazzarino interpreted it and said accordingly, and the like. So it's statutory. And that's the same thing that when two motions in limine that I highlight in my brief are addressed. One pertains to whether or not the hearsay should be excluded from the report and redacted. I win that, or my prior counsel wins that. But the one with regards to probation records, because they're mentioned statutory, are there, and you pull up the probation records, and there they are, right there in front of you. So you're stuck.
And the jury sees that.
No, that's the point. I mean, it's a gobbly mess. And, all right, so I want to talk about one more thing, and then I'll stop talking.
And your appeal is not based upon that. Your appeal is based upon, because
Because
you're
it's-
limited, right, because you have this
Case law going the other
Right.
way.
I'm stuck with the statute. I mean, I'm stuck with
I
the.
understood, so I'm not unsympathetic, I'm just trying to,
Yeah, I'm stuck with the statute, I'm stuck with Mazzarino, and every case that is followed from it, including even Markford acknowledges it and the like. The only other thing I want to talk about real briefly is this, and that's the development that he's made in treatment, that Dr. Bell recognizes, that now he acknowledges, now he knows he has to avoid situations that are in place, and most importantly, last thing I'm going to say, he has sex offender treatment as part of his probation. And one case that I took to this court 3 times, the man just was released on a Section 9. And the basis for the release was because they brought in enough testimony that said he's going to be on probation and he's required to get treatment. And that's basically what I'm saying is the situation here. He, according to Dr. Bell and the other experts, he's gotten to the point where now he's, the additional treatment he's going to get is going to get him over the edge. He's not there yet, Dr. Bell admits that, but with the pedophilia diagnosis, and I always say this when I argue these cases, so come back to me in 20 years? Because that's really what we got. If we got pedophilia, and if you're going to say he still has these problems and he's going to address and the like, I've seen many, many experts say you're never not in need of treatment.
Well,
Who gets to draw the line?
I mean, I think there's a serious constitutional question with the whole system when we send people to something called a treatment center for something that is untreatable, and then hold them for their natural life, which we don't even have in the criminal law anymore. Maybe we do, I don't think so. But that's not what this case is about.
can I just ask as a practitioner, and it doesn't really have any relevance to this particular case, although it's on the outskirts. Any idea, just in your years of experience, jury versus jury waived trials, how many people are convicted of SDP?
They never let us have jury waived trials. We went through all that during
Yes.
COVID, and I think the case was called Mackey, and a lawyer much smarter than I brought it up and lost.
Or even during COVID, you could.
Yeah, it was brought up during COVID, and I can't think what that lawyer's name, he was actually one of my mentors. That guy was smart.
And that's statutory as well, or just the Commonwealth won't agree to it?
The Commonwealth wouldn't agree to it. And he took every constitutional argument that he could, John Day's his name, and he brought it up and tried every argument in the world, and they said no. And then COVID cleared, it was over with.
Has there ever been a case in which the Commonwealth has agreed? That you know, just.
Maybe, I think I've probably have read a decision or two over the years, but certainly not many.
Right.
And they're not, I mean, frankly, if I was sitting in there, I wouldn't either.
No, I
I
understand.
mean, you know how these offenses are viewed by the common public? They're heinous. Well, kids, they're heinous. I have nothing further. If there are any questions.
Thank you very much. We will hear next from Attorney Crane.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. I think as the panel recognizes, this is a question of whether the evidence at trial was sufficient, not whether it was overwhelming. The testimony of Dr. PARRY by itself was sufficient to establish that the respondent was a sexually dangerous person. She testified based on admissible evidence and also evidence that was redacted from the record that the respondent met the DSM-5 criteria for pedophilic disorder.
So, in the traditional sufficiency of the evidence challenge, pretty easy hurdle for the Commonwealth to get over, right? And I'm not unsympathetic to the argument that, I mean, what if you propped up the one expert that has all the qualifications, that will dress in a suit and tie or whatever, and tell that jury, based upon my background and experience and review of all the records in my interview of this sex offender, yes, he or she is a sexually dangerous person. Every single time. no matter what. And defense counsel might have 6 experts to say, no risk, treated, gone through the program, all the rest. In the traditional sufficiency of the evidence analysis, taking out of the context of SDP, it seems fair. This one, I don't know how it ever, unless there's inadmissible evidence, could be that the Commonwealth doesn't succeed, and yet they could just have this one expert that everyone shares that says sex offenders are evil, they can never be treated, and here's all of my qualifications to support the fact that this person is going to repeat, even if that's not true.
I recognize the concern, and I admittedly am not an expert in the SDP world, but my understanding is that the qualified examiners are employed by the Community Access Board rather than the Commonwealth, so they are truly independent.
That's wrong.
That's incorrect.
Qualified examiners have to be approved by the head of the DOC, or they can't be qualified examiners.
But the Commonwealth doesn't get to pick and choose
No, they do.
which
The Department of Corrections Commissioner gets to decide who gets to be a qualified examiner.
I guess I mean in the sense that our office, the prosecutor, doesn't.
Okay, but the Commonwealth does.
So from the pool of people that you're picking from, right, they're picked by another entity that, picks and chooses, and I'm not suggesting that we have any evidence, I'm just suggesting that.
But that's not raised, I'm not saying it's raised here, I'm just saying.
No,
I mean, there's actually a lot, I mean, I've written something about this, but there is a case in which Justice Ireland called them independent. And then there's a huge amount, like when you look at how it's actually done, they actually have to be approved. So I'm not saying this happens, but the incentive is there to not approve someone who isn't saying what you want to hear. So
I recognize that could be a potential, but this is the legislative scheme.
yeah, I agree with that.
The legislator.
And you have to have one of the two at least, right? You can't do this if one of the two doesn't say sexually dangerous.
That's correct. And I think this case highlights the possibility that QEs do sometimes come up with an opinion that says not sexually dangerous, as Dr. Bell did here. But as always, when it's a sufficiency of the evidence argument, the question is whether we presented anything, and here we did. Dr. Peretti's expert opinion was the respondent had pedophilic disorder, and consequently, based on further interviews with him, he was likely to reoffend.
Is it correct that all of the experts agree that that the individual has completed all sex offender treatment available to him?
Yes, everyone was in agreement that he had completed all of the preliminary sex offender treatment that was available to temporary detainees at MTC. There were, I believe, 2 introductory courses that were available, and just before trial there had been a change of policy at MTC that was discussed a little bit, but the basic testimony among all of the experts was that he had completed these introductory courses that did not address deviant sexual attraction. They were more geared towards building life skills.
So the landscape has changed. Now he, if he wanted to, could engage in that type of treatment? Is that what I'm hearing?
I believe so. There was testimony at trial that because of this policy change at MTC, he had actually enrolled, but that had happened, I believe, after all of the examiners had completed their reports
And there are
and
cases,
trial.
I'm sorry to interrupt, but I'm sure that there are cases out there where a person completes all phases of every sex offender treatment module that the DOC has to offer, yet qualified examiners are in agreement that the person is still too dangerous.
Right, exactly. There may be situations where someone advances through the modules, but the examiners conclude they haven't benefited from them. It's an individualized assessment, and it's for the jury to decide whether to credit an expert's testimony as to whether treatment has had an impact.
Do you have any thoughts about, I know it's not raised here because it's a sufficiency case, But it seems very odd to me that there's a ruling that this information about these prior offenses or allegations can't be used. It's like the jury never sees it, but they see a report which the whole basis of which is that there were other sex offenses. So, I mean, I don't quite get that.
I'm not sure why that happened at trial. I could make a guess, but I don't want to. My only thought, just as far as that goes to a sufficiency question, is that the governing offenses that were discussed at trial and were unredacted from the report, I argue in my brief, support the idea that the DSM-5 criteria was met. So, you know,
But in reality, I mean, maybe that's true, but in reality, the qualified examiner you rely upon knew about and relied on the other ones. It may be that she would say only with these offenses, but we don't know the answer to that.
we don't know. She does have a conclusory statement. I can't remember off the top of my head in which page of her report, but she does say something to the effect that in the totality of these circumstances, there is a sustained sexual interest in prepubescent males.
Yes, but the only evidence of it is these other, I think, right?
Well,
He does say something to some interviewer at some point.
So the governing offense was one single criminal action, but it was 6 separate instances of sexual contact.
Yes, I agree, but I thought the point was that it was all within a 2-month period or something.
Right.
I mean, it's terrible, but
I think it's a reasonable inference for the jury and for Dr. Peretti to make, even maybe putting on blinders and not looking at the unconvicted conduct and saying, based on the DSM criteria, because you have 2 victims, so many instances of sexual contact, it's a reasonable inference to say that there were sexual urges or fantasies beyond just
But do you agree with your colleague that this can come in? This report based on this is not problematic, even though those events can't be mentioned and have to be redacted. That redaction without altering a conclusion or redacting the conclusion based on that is what's required.
I do agree. I think based on Markvar and Mazzarino, the expert can look at unconvicted conduct in the totality of.
Well, of course, but it's been redacted. The jury can't hear about it, right? It can't be used, allegedly can't be used by the jury, but of course it is used by the jury because it's the basis of the conclusion they presumably rested their conclusion on.
I think here with this specific expert report where it's not especially clear that the expert was relying on the unconvicted conduct for her baseline conclusion, I don't know how much it matters that her opinion may have been influenced by the unconvicted conduct.
Was 6 months in the DSM at the time of her opinion being rendered?
Yes, and she included that in her opinion.
Well, if she mentioned 6 months, she had to be talking about more than just the events.
I'm not sure I agree with that. I think because of the sheer number of instances of conduct against 2 victims over this a still extended period, albeit not 6-month period, I think it is a reasonable inference both for her and for the jury to infer that the DSM criteria, which goes beyond just conduct, it includes fantasies and urges, was ongoing for longer than just the approximately 1 to 2 months.
But even if it wasn't, you don't see a problem here.
Right, because the Commonwealth isn't obligated to present sufficient evidence of the DSM criteria.
But I'm not asking that. I'm asking you presented a report of the qualified examiner. In fact, you have to submit it under the statute. You submitted a report that was based on information that I gather was not permitted to go to the jury. Is the Commonwealth allowed to do that?
I believe we are.
Okay. And the basis for that, do you know why? Because it's confusing to me.
I mean, the statute does specify that the expert examiners, and even the jury, obviously in this instance, the unconvicted conduct didn't go to the jury, but the full record of the respondent goes to the examiner.
And what was the basis for not presenting it to the jury if it's presented to the examiner? Shouldn't they know about it so they can figure out whether they want to credit the examiner's report or not? And again, I'm not saying that's what's raised here. I'm just trying to figure out, it just
Right.
seems bizarre to me.
I'm candidly not certain why the motion in limine went the way it did in terms of
You
redacting
think
the reports.
that was an error under Masserino?
I think it certainly would have been permitted under Mazzarino for us to introduce evidence of the unconvicted offenses.
You're saying prior bad acts that that resulted in not convictions, but we're not talking about a criminal case of proving intent or motive. And I know we're getting far afield, but I think the judge got it right in not allowing in the prior not guilties to the jury.
And
Not the issue before us.
that may be, but of course, for appellate purposes, it is just a question of, was the evidence sufficient? If there are no further questions, I will rest on my brief.
Very good, excellent arguments from both of you. The case is submitted. The next case is number 24783. This is Commonwealth versus Corbett. And we will hear first from Attorney Contertesi.
Please the court, Adriana Contertesi for the defendant appellant, Mr. Corbett, who contends that the in-court identification of him by the victim was really inadmissible pursuant to the Creighton familiarity exception, and the prejudice that resulted from that really did deny defense cross-examination, and also to paraphrase what Creighton actually said about what resulted from this problem is all that is lost by barring suggestive IDs where there is no good reason is the unfair evidentiary weight of a needlessly suggestive show-up ID that might be given more weight by a jury than it deserves.
Okay, that's a police identification, right? That's not an in-court identification, am I right? I'm trying to remember.
The victim identified the defendant in court after the prosecutor assisted her in identifying him.
Okay, so the thing that was suggested was not a leading question. It was something that happened outside of the courtroom that impermissibly tainted the in-court identification in that case, right?
No, this happened in court. The prosecutor, when the judge...
I thought it happened when they were looking at the photo arrays. No? Oh, maybe I'm thinking of a different case.
So, but the problem I suggest with...
Pardon me, Judge, I quoted the little dialogue in my brief. It's right there. Yes, Judge, sorry.
So this happened in court when the prosecutor asked a leading question of the victim who appeared to be having some difficulty. Is that the person with the blue tie or whatever that you're challenging was error? And the Creighton line of cases has to do with when the victim and the defendant, who's now in court, sitting next to his or her attorney, and there's, say, for example, a robbery or a gunfight or whatever, and it's a white shirt and red shorts, et cetera type of case. And then the day of trial, do you see the person who did it? Yes, it's that person right there next to counsel. That impermissible vouching, that suggestion that because the person's sitting in the chair right there, that then they are the defendant when identity is an issue. Here, this is not the case, right? They knew, the victim knew who the perpetrator was. Now, the perpetrator, the co-defendants could say, it was him, but this is not a question of who done it.
Judge, the victim absolutely did not know who the perpetrator was.
He called him Rick.
And they
But-
lived together for a summer.
No, they didn't. The brother
Couple of
testified.
weeks.
The brother testified, right, the brother testified that Rick moved in the middle of June. He was out of there by the end of July. They had.
That's 6 weeks.
I haven't, that was 6 weeks, but that was 6 years ago. Creighton talks about a 27-month gap, there being no excuse for a 27-month
Okay,
gap.
let's look at this another way. Let's say that all right, I want to understand prejudice.
But, I'm sorry to interrupt, but I do want to just address something that
Yeah.
Her Honors mentioned, which is, you said that the prosecutor asked a leading question. The prosecutor did not ask a leading question. The prosecutor identified the defendant for the victim. When the judge said a white shirt's not enough, probably there were, court officers had white shirts, maybe people in the
All
jury
right, let's
box.
slow down, because you have the burden to show both an error and a substantial risk of a miscarriage of justice. And before the prosecutor said anything to the victim identified someone in the courtroom as the defendant, someone in a white shirt. Your hypothesis is, we don't know which person it was, but you've presented no evidence that how many people were there in white shirts? What is there any reason to think that he was identifying someone else, and that this coaching act, and it wasn't quite coaching because he said, is he wearing a tie? Is there another color on him? Now, is he wearing a tie might be leading. That seems clear to me. So he's, right, so now the victim is, by hypothesis, but you haven't proven this. There's been no hearing about it. There's no fact-finding. Maybe he's like, oh, the white shirt guy I picked isn't wearing a tie. I better go find someone here who's in a tie. And then he says, it's blue. And although you mentioned purple in the heading of your brief, you don't make this argument that it's really purple tie. Some people said blue, so okay. And let's say that's adequate to identify this guy. I don't know how many people were in the courtroom, whatever. So unprompted, he said white shirt. And unprompted, he said blue. Maybe prompted, he says tie. So now he's looking around the ties. But your hypothesis is he doesn't know who the defendant is at all. He's identified some strange person in a white shirt. I just don't see how you've shown that.
Well, first of all, the trial court did not think that white shirt was enough. And
I
we know
couldn't
that
agree
any
more.
court
Maybe there were
officers-
2 people in white shirts.
Well, we know that the court officers had white shirts, and what would have happened? What would have happened if that victim
Not
had
every
gone
error,
to somebody in the
not
jury
every
box?
error is a structural error. Not every error is automatic reversal. You have a burden to show substantial risk of a miscarriage of justice without knowing who else was in the courtroom. So, for example, the sibling. You suggest that maybe the victim confused the 2 of them. I don't know if the sibling was in the courtroom that day and could have been wearing a white shirt. You haven't shown anything like that.
No, there's no argument that the sibling, there's no record that she...
Okay,
But
so-
the 6 years ago that the defendant was at the house during the perpetration of this crime, we know that the victim would have seen both the defendant and his brother in bed with the mother.
So now you're saying, in fact, if the sibling wasn't there, yes, he may well have, or she may well, I don't actually know, the victim may well have identified the defendant, but really that was a confusion because they looked the same. What the defendant really meant was the sibling, But that has nothing to do with this tie business or that there's a different person with a white shirt.
What it does is all the facts that I set out at page 26 really show that this error was huge because defense counsel.
So
what kind
huge
of
that no
question
one
was defense
objected
counsel-
to it.
But what kind of question could defense counsel ask after that happened? Could she have asked the victim, if the
When you first
prosecutor
said
hadn't
white
helped
shirt,
you,
did you mean someone else?
if the prosecutor hadn't helped you, would you have pointed to the defendant? I mean,
Well, that would be a foolish question to ask, because the answer is going to be yes, and then you're reinforcing the identification.
But it just is a demonstration of a complete
It
deprivation
is
of
not a
cross-examination.
complete deprivation.
Yes.
I
of
don't even think
cross-examination
the in-court identification is that important to the case.
Well, I think it's totally the case, because the brother had so much motive to lie. And look, even the jury, who took 2 days to come to verdicts in this case, refer to the question that the jury asked. The jury said, does the brother, who got the favorable sentence on this second offense of statutory rape, will he still get to keep his favorable sentence if the brother isn't convicted, or will his sentence be increased? That was the question that the jury asked. So I don't think I'm making a mistake. This happened, it was first of all an error, it was a confusion and a misuse of the Creighton exception. And secondly, it was a due process deprivation.
Did the victim testify that 2 different people raped him?
Yes, she did.
Okay, so now what are you talking about? Why does the identification matter?
Because she left 2 notes. 2 times she had said only one person raped her, and she said that it was Rick, but there were plenty of facts to show that she could have confused these 2 people. And we also know that the brother had...
Sorry, confused them?
Yes, they looked alike. This was 6 years ago.
Where's your evidence even that they looked alike?
They went out and...
Where is your evidence in the record?
The same colored contact lenses.
My brothers both have brown eyes, but I don't think people are confusing us all the time.
Well, even defense counsel asked, at the time that the identification was about to be made, defense counsel specifically said there's a fraternal resemblance. These 2 were together in the apartment. They looked alike. They did the same things.
Can I interrupt for a moment?
Yes, sorry.
Would it be easier to consider this, that under the line of Creighton, the issue is, I didn't do it, that the victim misidentified the white shirt and the red shorts as me? And in this case, that is not the theory. The theory is, they did it, I didn't do it. It's not about identity, it's about guilt. And so sure, the victim in your version of the facts initially actually just said it was this defendant, Rick, and didn't include the co-defendant brother, right? But the tribal issue that the jury was trying to figure out is, who do we believe? The victim who testified that 2 brothers raped me, or not? That's not identification. That's just who's culpable.
No, it's an identification.
I'm sorry, your point is that the victim was confused. They looked the same. So why would the identification in court of someone who looks the same as the sibling be so harmful to you? As you can see, the victim continues to make this mistake, pointing to this person when really it was only the sibling.
If the victim had been unable, and that is why the prosecutor stepped in.
The victim was not unable to identify someone. The victim identified someone in a white shirt, and your hypothesis that it's a court officer seems a little far-fetched. Certainly you have no indication of that. But you don't even say how many people were wearing white shirts. Was there a person in a white shirt not wearing a tie? Was there? Because if there wasn't, then saying was he wearing a tie isn't leading at all.
Well, the trial court did not think that that was sufficient to identify the perpetrator.
white shirt wasn't
Right.
sufficient.
The
But
judge
that,
said, no, you need
okay,
more.
let's
And
say
that's
I've
when the
got,
prosecutor
all right,
said-
so I'm looking around this
I know, I
courtroom.
was doing the same thing. Every person I
Because it's a
presume
court, but although it's an appeals court, it might be different. Every single person in a white shirt in here is wearing a tie. So if I were to turn to Judge Henry and say, is the person in the white shirt wearing a tie? I might then say, oh, or what color? And I wouldn't have said anything leading because everyone in a white shirt is in a tie. But you have the burden of showing substantial risk. You don't have an affidavit from someone saying this room was chock-a-block with white shirts without ties. Do you see what I mean? I'm having a hard time. How are we supposed to know how big a deal it is without knowing what the risk was?
Why didn't, in the entire 6 years, the entire 72 months, as opposed to the 27 months that Creighton found, that gave no excuse for not having a show-up identification, why during that entire 6 years had there never been a show-up identification by the victim of the perpetrators of the crime?
The victim knew who her perpetrators were. You do a show-up when you don't know them. And so if the alleged perpetrator was dad, do you think they have to put 10 dads in a room and say, that's my dad? No, we don't do show-ups when identification is not an issue. When guilt is an issue, we go to trial.
I mean, this wasn't a situation where the child was saying only one of them raped the child. The child was saying they both raped
Well,
the
she had
child.
said that before, that only one of them raped her.
I'm not going to fuss about this, but
Two
we do
times.
tend to respect people's pronouns, and I think the victim is now
Oh,
he.
pardon me, Judge.
And I'm not taking, it's confusing because we have two different transgender people here. But this isn't, I could see your point if the issue was that one of the siblings raped the victim, but the victim is saying they both raped the victim.
And the brother had, the other perpetrator had a huge reason to fabricate, to protect himself, and that the jury recognized.
Okay, but in oral testimony, the victim corroborated that story. Maybe also lying, but corroborated it. I'm just having a hard time understanding why I say it's Rick and the sibling, and then in court I identify Rick, who's the only one here, instead of misidentifying, just saying like, I don't remember what Rick looks like, and I choose that person over there. It just doesn't seem that, given the oral testimony. All right, but
Well, at page 26, I do list a number of reasons why the victim would have been confused about the two perpetrators, and that she also had a reason to point to my defendant as opposed to only the brother, to appease her excellent friend, for the victim to appease the victim's
I think we
excellent
understand
friend.
that. All right, thank you very much.
Thank you, Judge. Thank you.
We will hear next from Attorney Lee.
May it please the court. ADH Lee from Middlesex on behalf of the Commonwealth. It was not the prosecutor who identified the defendant in this case. It was the victim. After the victim described the defendant wearing a white shirt, the Commonwealth asked a follow-up question, quote, does he have a tie or another collar on him? This was not leading because it did not suggest the answer. It was merely a forceful signposting. I understand this could lead into leading based on different circumstances, but in this case, it was not leading because the victim did not say yes or no. The victim actually said a blue tie. And further, the victim identified...
That's a lot like yes to the tie part.
Excuse me?
That's a yes to the tie part. Does he have a tie? Does he have some other color on him? A blue tie, the blue is volunteered, but the tie part was suggested by the prosecutor.
No, Your Honor, simply because a question may be answered as a yes or no does not make it a suggestive question. And regardless, there's no prejudice like Your Honor discussed earlier. This is a case where there are three other witnesses identified the defendant at trial. The victim identified both the defendant and the co-defendant as someone who raped the victim. There is a contemporaneous note the victim wrote to the police that it was the defendant that raped him. And there's past messages between the defendant and the co-defendant describing, admitting to each other what they did to the victim in this case. In any event, there's no special risk of miscarriage of
So
justice.
what would have happened, I've said to your colleague, look, maybe it doesn't matter so much about the identification. Let's imagine that after having said a lot, one person did this, admittedly Rick, but one person did this. Then when asked to identify, is the person who did this, who isn't the sibling, is that person in the courtroom? Yes. Who is it? And they point to some intern from the prosecutor's office or somebody.
Yes, sir.
What would that have done to the case?
So that would make the in-court identification done by the victim improper in that scenario, but it would not affect the case because this is not a situation the victim was saying that was the person that raped me years ago. The victim was simply identifying the defendant as the person sitting in court. So the context that the victim done in this case is the same thing the other three witnesses done in this case. This person sitting in court right now is Richard Corbett. It's not a case where we're doing a show-up or prior identification like Justice Walsh talking about creating cases. This is not that situation.
Why are you asking the victim that? I mean, other people have said, oh, yeah, that's Richard Corbett. Why do you ask the victim if it's an unimportant question?
So it is simply to identify the defendant in court today is actually the person they were describing earlier.
I understand that, but let's say the white shirt person they were thinking of before, and I don't say there's any evidence of this, was not, in fact, Richard Corbett. It was, like I say, an intern from the DA's office who they're obviously wrongly think, oh, that looks a lot like the guy, whatever, and they say, okay, so it's that person. What happens? What happens in the case? That is, why do you say that wouldn't have been any different?
I would say it would make a difference if the only evidence of in-court identification and any identification is through that in-court identification. But this is not the case here. My point is, if the only time to connect a person in court and counsel table to Richard Corbett was the in-court identification done by the victim, I can see there's a difference. But this is not the case. This is a case where three other witnesses identified the defendant. There was a prior identification written by the victim, identified it was Richard Corbett that raped him. And three other witnesses identified the defendant sitting in court was Richard Corbett. That makes no prejudice in this case.
So I guess, with the hindsight and ability to review, you could say the better practice would be to say, describe another article of clothing, right? But people are entitled to fair trials, not perfect trials. And so the fact of the matter is that prosecutors can choose to have every witness identify the person next to the chair if they can, or just one, depending on their practice. Might be overkill, it might be not necessary, but they can do it, right?
And that's exactly right. It is sometimes more formality than anything, as the court acknowledges, is simply to confirm the defendant sitting in court today was the person being accused.
How would...
Because a record is read by appellate judges after the fact, and we ask these questions of how would we know that the white shirt is the defendant? The trial judge was 100% correct in saying, give me a little bit more information so that the record can reflect that that person sitting there is that person. And so while it may have been better to say, describe another article of clothing, or are they wearing glasses or not, or X or Y, is there anything wrong with what he said? And your position is no.
Exactly, and I agree the question could be more open-ended. As Justice Rubin pointed out earlier, this is a case where there was no cross-examination. The defendant could have cross-examined the victim on the case. It was not done. The jury also had opportunity to observe the in-court identification. If anything was incorrect, something would happen. But it did not happen here because identification was correct.
How would a defendant ever show a substantial risk of a miscarriage of justice?
For this type of alleged error, I don't think there's any, it's ever possible because the evidence was so
powerful. So this error can't be reviewed effectively on appeal if it isn't objected to below, but we do allow waived claims to be reviewed for substantial risk of a miscarriage of justice.
Correct. This court still reviewed it, but I could hardly imagine when a case will actually be overturned based on this issue alone.
So if I were to say, were you working on the night of January 3rd, 2025? Just because you say, yes, I was, doesn't mean that that's a leading question. Right?
Exactly.
You're not asking for a particular response.
Right. The commentary is, isn't he wearing a shirt? I understand it's a very limited way of looking at leading question, but leading is not as broad as a lot of people think it is. If there are no further questions, the comment on brief.
I see none. Thank you very much. The case is submitted. We will take our traditional mid-morning break and will then return for the remaining cases in approximately 10 to 15 minutes.
Please. This court is now in session. Please be seated.
Good morning. Our next case is number 24303. This is Department of Children and Families versus Child and Another. This is an impounded case, so we're going to not use names. We're going to ideally use words like child and mother. I gather on the appellant side that counsel for mother and counsel for child will be splitting their time. We've been told 10 minutes and 5 minutes.
That's correct.
All right, and so we will hear first from counsel for mother, Attorney Musharit, whose name I've mispronounced.
Good morning, members of the panel. May it please the court. My name is Michelle Musharit, and I represent the appellant mother who's watching through the YouTube channel. I'm here to ask this court to remand this case because the department's plan does not provide for the child's permanency, stability, and renders this child legal orphan. Let me start by saying this is a sad case. It is a sad case because it involves a child who, by trial, continues to wear pull-ups. He's nonverbal. He communicates with the outside world using iPad. He is unable to care for his daily activities of living, and therefore he will be relying on others to do so. We have also mother.
I take it that the child has not been adopted.
The child has not been adopted, Your Honor.
Okay. And you argue in your brief that he's nonverbal and recruitment is not an appropriate adoption plan for him. And I didn't understand why him being nonverbal means recruitment's an inappropriate plan.
The plan calls for adoption by recruitment. In order for him to express his wishes, he will need to communicate. In fact, the plan calls for recruitment, and there is 1 in a million chances that the department will find someone. The department's plan is to recruit an angel who's willing to adopt this child, willing to accept the fact that this child will rely on other people for the rest of his life. The fact that this...
So are you saying it's a clear error on the judge's part to have concluded that adoption was a possibility?
I'm arguing that it was an abuse of discretion, Justice Rubin, that this judge approved a plan that calls for adoption by recruitment, knowing that this child may not be adoptable.
Well, every child may not be adopted, right? But you're saying there's a very tiny likelihood. I suppose it's not 0, but it's very, very tiny. So, and tell me why, I mean, everyone uses this phrase, legal orphan. What difference does that make?
In this case, it does make a difference, Justice Rubin. We have case laws. For example, we have Flora, adoption of Flora, where the parents' rights were terminated, and this court remanded the case because it was not in the best interest of the child. There are certain situations, Justice Rubin, where parents may be found unfit, but they don't require termination order. In this case, we have a mother who's willing, with all her imperfection, okay.
To do what? She can't have custody of this child. You're not arguing for that.
And no, I'm not, Justice Rubin. What I'm asking for is to amend the case.
I'm trying to understand how would I put this? There doesn't seem to be any indication, I can't say it won't happen, non-zero chance, but there doesn't seem to be any indication of improvement in the mother's ability to parent. That's over the 10 years that the child was with her, where, you know, the level of neglect here is, as these cases frequently are, is quite terrible. She is entitled to visitation now. I understand that could change in the future. Although even without termination of rights, it's still up to the court. DCF is the legal custodian of the child now. So I'm trying to figure out what difference it makes whether she continues to be, I mean, I understand she could bring a redetermination every maybe 6 months or something. But it also seems to me that termination may make it easier to adopt this child, even if we're only increasing it from 0.1% to, 1% to 3%. And so that's something of benefit, maybe, to the child. I mean, maybe the answer is this child is not adoptable. And that wouldn't surprise me at all, and I'll ask the department about that. But everyone uses the phrase legal orphan, and I'm trying to understand what that means in the context of a parent who really, I mean, maybe you tell me she might, I think it says in one of the briefs, she might get better in the next 6 years. But is that why it matters, or does it matter to the child? I don't understand.
Justice Rubin, realistically speaking, we have a child who is not adoptable. Even by the court record, the judge expressed her concerns about the department's.
Yes, but at the end she says, I believe this child is adoptable. She actually wrote, and will likely find a pre-adoptive resource soon. That's how the opinion ends.
And I agree with you, Justice Rubin, except that what the department was trying to do is trying to convince the court that they will find adoptive parent, despite the fact that the adoption worker herself testified that we, quote, we may never find a family for this child, given his needs.
But the question is, though, if the mother is not fit and does not, and let's just pause. You're not contesting you're not challenging the finding the mother was unfit, right?
I can concede to that.
And
Justice
was
Henry.
not going to become fit in the foreseeable future, right?
And I also concede to that. What I'm arguing, if I may, I'm arguing that there is no need for termination in this case. This case does not.
But we can only, but this is my concern, though, is to try to have the child be adopted. The child's much more, if you take two children and you have one child without parental rights and you have the exact same child where the parent still has rights, the child where the rights have been terminated is more likely to get adopted, right?
Yes, I agree with you, Justice Henry.
So we're trying to give the child the best chance to get adopted, even if they might not. That seems like what the judge was trying to do.
And I agree with you, Justice Henry. That's what the judge was trying to do. But realistically speaking, this child will never be adopted. An angel cannot just.
But this is, well, so my question to all three of you is why can't we have the best of all worlds? Why can't the judge terminate her rights, but put in the decree, if he is not adopted by the time he's 18, and that the mother's rights will spring back into existence? Why can't we do both?
That would be ideal, but that's not what this judge.
No, I understand, but is there some reason why that can't happen? Why the judge couldn't do that?
The judge could have easily terminated and not issue an order. And the reason why, that would give the department chance to file.
No, they still need to come up here, and because until we sign off, it's still this thing hanging over the child.
And I agree with you, Justice Henry, but until someone is identified.
But, well, I mean, I have seen children that I couldn't imagine someone would adopt them, and they did get adopted, and I'm thrilled for them. So I don't think we can just say he's not adoptable. We can say he didn't get adopted, but I don't think we can declare him not adoptable.
Justice Henry, if the department could not find foster parent for this child between November 2020 until the end of this trial in 2023, then how are they going to be able to find adoptive?
And it's now been another year, is that right? It was November of '23 that the trial ended?
Yes.
Oh, and then we get the findings and so on in January, is that
Correct.
right? And now it's January, a year after that. And I assume recruitment efforts have been ongoing. No pre-adoptive resource has been identified, is that correct?
I agree with you, Justice Rubin.
But when we're looking at through the lens of abuse of discretion, my concern is that, separate from the unfitness, right, is that, and I understand your position. It's not as if there's an aunt out there waiting in the wings to say, I understand all of the child's issues, I will take them in and care and love them, right? We don't have that, unfortunately. But to say that it was an abuse of discretion when, other than in your brief saying an angel appears, right? You're saying never in the history of the Commonwealth of Massachusetts is a nonverbal child ever adopted, and I think that.
Well, nonverbal 12-year-old who's not toilet trained and who has to have their mother involved, right?
In this situation, I imagine that somewhere, no, it's slim, recognize that, but abuse of discretion to say that no one ever will adopt this child? Like, I don't know that it's enough to just say, well, an angel would have to appear, and so therefore it's an abuse of discretion. When you have a plan, and they're not sugarcoating it and saying, oh, this will be a breeze, they're saying all of these issues, but here is our plan, that the judge abused their discretion in saying, okay, that's sufficient, because that's what they have to show, is enough content in there, right, in that plan, in the adoption plan.
Justice Walsh, what we have is, as Judge Rubin pointed out, even, and this requires me to step out of the record, a year later, nothing has happened. Year later, nothing has happened. And what I'm arguing, Justice Walsh, is that is it the best interest of the child to cut out all ties with his biological mother when there's nobody out there? Every child needs a parent. This child, by the beginning of the trial, had one. The end of trial, he had none. So at this point, where he is right now, what exactly is he receiving? He's receiving food, shelter, and some treatment. Child needs more than that. Child needs more than that, and that's what I'm arguing. What I'm arguing is best interest of the child requires more than that, requires a parent, especially this child. Sense of belonging is not there. Sense of belonging gives the children safety. And that's required for their growth and development. In this case, the mother was the only one there. With all her imperfection, she wants to be part of the team. She wants to be part of his clinical team, therapeutic team, educational team, whatever it takes.
So
why terminate when permanent custody would serve the purpose? Yes, Justice
You
Henry.
make an argument that the department believed that ending the visits with the mother would be the humane thing to do, but I didn't see a citation in the record for that. There is a reference in the transcripts, but I didn't, it's not clear from this context. So do you have a record cite for that? Because when I look at this transcript, I can't quite figure out what the department was thinking. I mean, this witness, Ms. Clement, testifies on page 765 of that volume 3 that it felt like the humane result in this case, in this matter, to be quite candid. But I couldn't figure out what it was that was humane.
It was a transcript, volume 5, and I believe it was page 262, Justice Henry. Going back to the goal, with termination, I should say without termination, the child will still remain in DCF custody. And in accordance with 119, Section 26C, DCF can, once identifies adoptive parents, can file a motion for review and a determination and come back to court and tell the court that is, we have a plan, we identified someone. This way, this will give the court a chance to oversight this case, but to terminate and leave in nobody to fill in that gap, that's not in the best interest of the child.
So the department argues that even if the mother wanted to be part of the team, that historically the mother was resistant to following provider recommendations and made various excuses about why she wasn't. And so, in fact, it's a nice idea you're presenting, but it's not in touch with the reality. What do you say to that?
Well, the mother, although she continued to visit the child on a weekly basis, the mother noticed that...
Which is impressive.
Yes, and I agree with you, Justice Henry. She noticed that some of the services provided in the program are beneficial to this child, which is the reason why she's not asking custody to be returned. What she's asking for is permanent custody to allow the department, once the department identifies someone. It is extremely hard for parents to agree to adoption not knowing what the future of the child holds. And this is the case here.
How recently have you spoken with your client?
As recently as Saturday.
Okay,
I had a lengthy
and
meeting with
is
her.
visitation still going on?
It's still going. It takes her all day. She uses public transportation.
Okay.
So she spends 4 hours with him.
All right, your time has expired. But
If there's
there
no
are
question,
I just, I'm going to ask all three of you this question. Is there any, if he's not if we affirm and he's not adopted and he turns 18, is there anything that would prevent the mother from being able to, for her to adopt him?
well, by the time the child turns 18, the
You can
custody,
adopt an adult, though.
she probably would. She wants the child. She wants to be involved.
Right.
So she probably would move in, but until then, this child needs an adult who can hold his hand and transition him to adulthood.
I think we
Okay.
understand, yeah.
We will hear next from Attorney Taylor, and I have every reason to think we'll keep you longer than 5 minutes, but I guess we'll see.
Thank you.
Thank you.
Good morning. May it please the court. Susan Taylor for the child. I'd actually just like to, although I had prepared this somewhat differently, I kind of want to pick up on the thread of Justice Walsh talking about whether or not it was an abuse of discretion for the court to terminate mother's parental rights. So an abuse of discretion, I think in the LL Commonwealth versus Commonwealth case, I think it clarifies what an abuse of discretion is. It's really not sort of a conscious disregard, but rather whether or not perhaps the weighing in this case may have not been exactly appropriate. And in a termination case, I mean, I think it's clear that everyone concedes that mother is unfit. But the question is, the fact that she is unfit doesn't mandate termination. And instead, we engage in somewhat of a cost-benefit analysis. So the benefit, seemingly, to termination was that, according to the department, that it opened up avenues for adoption. But as it turns out, I mean, if you look at the evidence that was presented by the department to support that, I would suggest it was meaningless. They cite statistics of how many children get adopted, but it's a moderate to severe special needs without any regard to the age of the children, what the disability is, it is educational. And in this case, my client came into care in November of 2020. He is now going into his 5th year in foster care. So he has been in 3 different facilities. He's now currently at the Rotenberg Center, where basically he gets 24/7 care. And his mother visits him 2 hours a week, every week. She goes for his birthday. So what we have is that the possibility, the benefit of the possibility of adoption versus the question to Justice Rubin's question about what is a legal orphan. Well, for practical purposes, once mother's rights are terminated, she is no longer invited to foster care reviews. She is no longer entitled to the appointment of an attorney in this care and protection. Her rights are terminated. And in this case, one of the things that the case, that in the Gertrude case, is that there is a relationship between my client and his mother. And although the government, in its brief, talks about how there are other caring adults in my client's life, the fact is that all of those caring adults all get paid to care about him. And I mean, I'm not saying that that's necessarily a bad thing, but what is the value of his mother? That she cares about him, that, you know, she...
Your points are well taken. I guess the question, though, is can we say it's an abuse of discretion to give the child a better chance, however small, to be legally adopted?
Well, there's no reason why that has to be the decision now. The court could have adjudicated, I mean, the court can adjudicate the parent unfit, and now in the 5th year, if a person came forward to actually adopt this child, but where do we leave off from possibility to speculation? When the court talks about a fictional being coming forward and giving this child a home, well, you know what? If we're talking about only an angel, if you look at the testimony of the 2 social workers, one of them knows of 2 people. She's a 30-year social worker.
It's tiny. It's tiny. That it seems like that's what the record established.
Which goes to the point of weighing it. So if we're going to weigh it.
So why can't we have all worlds? Why can't we terminate her rights, but if he's not adopted by the time he's 18, her rights spring back into existence? Why can't we do that? Then everybody gets what they want.
Well, I think actually when he turns 18, at that point there would have to be a guardian appointed to manage him. I mean, he's not going to be in the care of the department anymore. So, but that's 5 years away. That's 6 years away. He's 12.
Well, I take it that the difference would be things like participation in the
foster care reviews.
And maybe, I don't know, if DCF wants to change the visitation schedule, would she still be entitled to litigate that after termination?
Well, I think that if there was the court would have to make a determination as to what is the appropriate amount of visitation. That's the interesting thing about it in this case, because on the one hand, one of the reasons that they say that people are more inclined to adopt if parental rights are terminated is because there really is not that kind of ongoing contact with the mother. And in this case, the court is talking about any adoptive parent should understand that this mother is going to be in the life of this child for all of her life.
Can I ask you a couple questions that are outside the record?
Sure.
In the ensuing year plus since the trial ended, has DCF been trying to recruit someone?
I'm told that they have listed him on mayor. I personally know that I saw a post on a social media that had a picture of him, but there has been no change.
Has there been any interest expressed by anyone in adopting the child?
No, and not only that, Your Honor, one of the things that has to happen before that even occurs is he would have to be stepped down from the level of care that he's in. He's never going to leave that. Are they continuing to look for a foster home or to step him down so he can be in, I don't know if anyone would volunteer for this, but to be in a foster home that's a home rather than an institution? but they're not able to clinically approve a step down. for him.
Okay, so the level of care that this child needs can't even be provided right now in a house, so that adoption is literally impossible right now.
That is the logical conclusion.
No one has said that?
No, as a matter of fact, I think one of the things that the judge says at the conclusion is, I would imagine that the first step has to be that you have to get him to where you can step him down from the level of care that he's in to a foster home, and the social worker's testimony says, we're working on it. But that has not been determined.
And you're using a substituted judgment here, is that?
Exactly what I was going to ask.
I mean, he can't,
No, he's nonverbal, Your Honor. I mean, I do
Well,
go
I know,
see.
but there, people can be not verbal, and I worked in a group home
Right.
for, at the time, we would have said mentally retarded adults. I don't think we use that language now, but that we had nonverbal clients who were quite good at, really quite impressive at
Verbalizing, yes.
communicating. So but you're using your judgment, right?
Yes, and that was also the substituted judgment of the trial attorney.
No, I understand, and I understand.
This was the child's position at trial as well?
Yes, yes. Although I will say, I mean, I did file a late notice of appeal because at the time that I was assigned, I did have a conversation with trial counsel, and she had told me that she did not realize that she needed to appeal the TPR aspect of it. She thought because mother was appealing, the child would also be afforded the chance to.
Oh, I see.
Okay,
So-
that's helpful.
Unless
Just one quick question. You write in your brief, according to Dwyer, which was one of the witnesses, it's more difficult to find families for children whose parental rights remain intact. Are you doubting the accuracy of that assertion? Or you're just saying it's not meaningful here in his circumstance?
Well, I'm not arguing, I'm not suggesting that it's untrue,
Right.
that they have 73 matches for the 168 children in care. But rather, the way that it is described makes it a meaningless assertion for all we know. Maybe the kid has a lisp, and, that somehow qualifies them as medium to severe. And especially when we're talking about, I think it would be a much more meaningful statistic if we were talking about children with severe special needs, because that's where we are.
You believe, I understand this isn't a clinical diagnosis, it's not in the record either. You think that this child is never leaving this institutional setting? You think that's not possible?
I don't.
All right, thank you very much. We will hear now from DCF, Attorney Gallup.
Good morning, may it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the decree of the lower court terminating mother's parental rights. There has been a bit of discussion about things that have happened outside the record, and I did want to correct some of that information that's been communicated, if you would let me. It's my understanding that the child still is at the Judge Rottenberg Center, but that the social worker the adoption social worker, has found that he can transition to a foster home, and that as recently as this fall, there was a potential foster parent identified who met with the child, but then decided not to move forward because was concerned with how the new child would interact with children already in that home. So I just wanted to give you that information that, whether this child needs to stay in a facility until he's 18, that's not my understanding of the facts.
Might it be worth remanding for the judge to consider that possibility?
So the judge did not abuse her discretion when she found that the department's plan was sufficiently detailed and served the child's best interest. And the trial court, the juvenile court, retains jurisdiction over implementation of that adoption plan through the annual permanency hearings, Section 29B. So if this panel determines that it was an abuse of discretion to find that this plan was in the child's best interest, then certainly remand makes sense.
It's a question of termination, not of the plan's adequacy.
Pardon?
The question is about termination, not about the adequacy of the plan.
But part of what the court is looking at when deciding whether or not to terminate is, does termination serve a child's best interest? And part of that, analysis requires looking at the plan.
Right, but their argument is that, yes, it seems like they're saying, yes, if her rights were terminated, it does somehow, some percentage, increase the chance that he might be adopted, but that the chance he's adopted is so low that whatever that marginal bump is, it just is an abuse of discretion to terminate in this circumstance. Why is that wrong?
Because the judge's findings about the department's confidence in being able to find a family for this child, the judge made findings about the department's ability to find a family for this child. And those findings have not been challenged as clearly erroneous.
Well, yes and no. They're arguing that those findings weren't really realistic, that the judge didn't really dive into the true likelihood that this child will be adopted, and that, in fact, the prediction has proven to be incorrect so far. Doesn't mean it will be, but, and that this mother, the fact that she's maintaining these weekly visits and getting there from a long distance, just maintaining the weekly visits is very unusual. The fact that she's doing it with public transportation, et cetera, is almost unheard of in these cases. It's impressive. It's impressive.
To her credit, it is impressive, but at the same time, she had an obligation to help this child grow and develop, and
nobody's challenging that she was unfit to be able to maintain him in her household. But the question then is, what's the significance to the department, right? That she can't participate in the 6-month reviews?
the significance to the department is that every child deserves to have a family. And so the significance to the department is to ensure that a child...
a year has now passed. There hasn't been a nibble, not a bite, nothing, and you haven't even found, and I can't say I'm surprised by this, a home that will take this child on a foster basis, because let's not sugarcoat it. It's a child who's profoundly disabled, who has to wear a diaper at age 12 or 13, however old he is right now, and will, I would guess, have to for the rest of his life, since he's been 5 years in an institutional setting and that hasn't changed, who also is required by what the court has found in the child's best interest to deal with the mother of this child, who is not only unfit, but has, among other things, schizoaffective disorder. This isn't, I'm not saying there isn't a person in the world who would do it, but I've never seen it. Now, I don't see as much as you do. I mean, I see cases like this every month, unfortunately. But I've never seen anyone adopt a child like that. What we've sort of heard through various representations made to us in court is that after a kid gets to be about 10 years old, it's really hard to find someone to adopt them to begin with. So I'm just saying, I'm not saying that this is necessarily wrong. I'm not saying it requires reversal, but wouldn't it be wise for the child's benefit? Because as Mother's Council points out, there is a difference between it's your mom, even though she's wildly inadequate, if you're this disabled, and it's people who are paid to care for you in an institution. Mightn't it be that, having seen that the predictions really, at least for now, haven't come true, although we don't have, that the judge takes some testimony on this, try to figure out whether really it is in the child's best interests.
I mean, I just would reinforce that this child deserves the opportunity and the chance to make that connection with a family. And so, to the extent that this child would need a type of guardianship, once he turns 18.
And he will.
The fact that he would have a family and that he could have adults who were there.
Everyone agrees with that, but you haven't found a
But
family.
that's not to say that we won't. And I don't know that.
How many years will it take? Because he's 13.
Well, which leads me back to the question I asked, which is why can't we give everybody what they want? And instead of having an and, this or that, why can't we have a both and, which is we terminate the rights, it goes through appellate review, but if, you don't succeed, then her rights spring back up. Because otherwise, you're asking a person who's got a lot of challenges, probably without an attorney, to do an adoption. Right, whereas we could do no harm, at least put them back where they were.
I mean, I guess.
Is there a reason why we can't do it? We meaning the system, not the three of us.
Sure. I mean, I would think in terms of, I guess I don't really know how that would play out. Let's say like next month, there is actually a foster family identified, the child transitioned to that home.
If they get adopted, then her rights don't spring back up.
That wouldn't solve the problem for the next 5 years in the mother's ability to be involved, or if things change, to have an attorney or a voice. I guess my point here is that, A, I think we all agree this is a terribly sad case on so many levels.
Terrible.
B, I actually think you're speaking the same language about a child's right and to have a parent, but the counsel's point about the weighing of the evidence, it's what the child has now versus the reality of what the child might hope to get. And I don't know if that was based in reality. So in other words, for a moment, just think of, for a moment, the facts are the same. And if the child even was 5 years old, and we could put it in the computer and say, we can predict that nobody for the next 13 years will ever adopt this child, right? Then I think that's an abuse of discretion, because that plan isn't in the best interest of the child for 13 years to be strung along while the parent's rights have been terminated, because there's no hope, right? Mm-hmm. Okay. And so here, when I think of abuse of discretion, if the judge said, the department, and I'm not faulting the department because I think everybody here is trying to do what they consider to be the best out of a worse situation. If the department looked at the judge and said, hey, not hey, judge, in 173 cases, 20 of them were severe special needs. And 15 of those 20 were children over the age of 10. And guess what? We found a home for them. Hard to believe, but we worked our tails off and we did it. I think that's not an abuse of discretion, but the absence of, other than just a kind of children deserve parents, this is, our hope. We are not giving up that a family isn't out there, but the absence of any evidence that this is anything other than really wishful thinking, I didn't see in the record. And I wasn't looking specifically with this eye, but I was looking with a little bit different, but that the department ever said, severe special needs, this type of situation, we've done it. And so the judge could say, okay, then I weigh that evidence and I do that. Can you respond to that?
I mean, the absence of that more precise evidence is, I guess, an issue, but to the extent that the judge, was able to hear the witness testimony and determine, this was credible, this was a credible
No, not this person, but the idea of that adoption is a real possibility. So in other words, if there was more development of, we had a similar case, and we found an adoptive home. We had 5 similar cases. We had 95 that we couldn't adopt and that lingered, but we had 5. I feel as if on appellate review, that's not an abuse of discretion. That's weighing and that's considering. But here, I just get this kind of, here's how many people we put through this process and we go through, and yes, some get, but they're not all alike. And so that's where I find, to me, to be the ear of abuse of discretion. It's not that anybody necessarily did anything wrong, but I don't know that the evidence was there that could be properly weighed.
Well, I mean, the department takes a different position than that, but I mean, I do think that, you know, you're thoughtful, you know, what you, as you've kind of discussed it just now, is thoughtful, and, you know, these are the facts as they were, or as, you know, as they were presented.
Thank you.
So in the transcripts, there just seemed to be a reference to the department thinking it would be humane to wind down the visits with mom, or at least that's what it looked like it's saying. But it's not a witness that's testifying. It seems to be the attorney. So can you just explain what's happening there?
Yeah, I believe, I don't know if that was in the lobby conversation or if it was part of counsel's closing argument, but that was from DCF trial counsel. I don't know if it was in response to a question from the judge about what the department was thinking of doing in terms of visits, and then counsel explained that, you know, the plan would be to decrease the frequency, or I think that was the context of that.
The order right now is mom can see the child weekly.
Yes.
And you would have to go to court to change that?
The order as written is that the current visitation order between the subject child and his mother shall remain in place until further order of this court.
Okay.
So, you know, the department would then need to do something to change the visitation order.
So is the mother correct that when she states that DCF brought the motion for termination without taking any of the recruitment steps available to the department prior to termination?
I don't know what that is in reference to. I'm not recalling.
Well, I guess the question is do you know if there's any record evidence of the department trying to put the child in recruit adoptive family or a foster family prior to termination?
Yes, so that was, I believe, I don't recall which social worker that testified was speaking about how I think the child had been recently brought to a recruitment event, like at some point previous to that trial date. And there was also testimony about after termination, I know after termination, then the child's photo can be displayed on certain websites, but that prior to that occurring, that the department was working with the various entities to, you know, connect a child with a family.
So a disabled child can obtain Social Security benefits through a parent's earnings record. So does termination end that right once they're legally not the child anymore?
I mean, I would assume so. I know that also just in general, I think there may have been a change recently, but it's my understanding is that when a parent is receiving Social Security on behalf of a disabled child, that if that child enters the department's custody, there is usually some sort of representative payee made. I think that they may have recently changed that, but I know that that is something that occurs.
And termination cuts off their inheritance rights, not just from the mother, but from anyone in the mother's family, right? I mean, they can leave it, but it doesn't, but under the laws of intestacy, the child would just not be counted anymore, is that right?
That I could not tell you with any degree of confidence, but, so I don't want to say, I mean, I would assume that.
Well, the child also argues the judge failed to account for the fact that in a short amount of time, the child would have been able to object to being adopted. What do you say to that?
So by statute, and once a child is 12, the child has to sign an adoption consent form. And so, but the evidence as presented is not clear about what the child's position actually is, as counsel has substituted judgment at the trial level and at the
Assuming the child can't actually consent to anything,
Well,
do you then have a GAL? Do you have the child's lawyer? Who actually decides whether to consent or not?
Well, I think it would depend on whether or not the child is competent to understand.
That's what I'm saying. Assume the child is not competent, which is what this sounds like.
If the child is not competent, although I don't know that that's actually, because the evidence in the record is that he's able to understand the language. It's not that he doesn't understand, it's just that
But
he
we're
cannot
using
communicate.
substitute, I mean, at least under the CPCS rules, apparently it's been determined by CPCS that it's a substituted judgment case. So if the child is not competent, who does that consenting?
I'm not, I don't know that the CPCS standards address that, but I believe that the most kind of professional responsibility approach would be to have a guardian ad litem appointed to, make a decision on the child's behalf.
I see. Okay.
So what happens when this child, if this child turns 18 and has not been placed anywhere? Because you're saying that once he's not a child anymore, something happens. You're not going to put him on the street, I presume.
Correct. I mean, I'm not, this isn't something that I prepared for to answer, but I would assume that working with perhaps the Department of Mental Health, some other type of entity would then need to file a guardianship petition on his behalf if he's not able to make decisions for himself. And I don't know if that would be an attorney appointed or some type of clinician.
So the child asserts that the visits, the interactions between the mother and the child are loving and positive. Do you disagree with that?
I know that there was information in the guardian ad litem's report that basically when they interacted, the child was just on mom's phone and there was no interaction between mother and child. So I would disagree with the characterization in child's brief, given some of the observations from the GAL.
We very much appreciate the extra time all of you have given us. Your arguments are very useful to us, and these are, of course, among the most difficult cases that we hear. So thank you all very much. The case is submitted.
Thank you.
So the final two cases involve pretty much the same parties and certainly the same counsel on each side. And they are paired cases, though not consolidated. My inclination, to some extent it will depend on how deeply we get into various issues, is rather than having two separate 10-minute, 5-minute arguments, that we basically start with, that we basically do it as one argument, but we may take extra time, as we seem to have been doing all morning with all lawyers, to make sure that we've delved into each of their, the differences between each of them. But you are entitled, of course, to two full 30-minute arguments. So I want to get your feedback on doing it that way.
I'd be happy to do what you described.
You too?
I have no objection to proceeding in
All right.
one argument per side.
All right. So let's do that. We will hear first, I gather, so these two cases, I should call them, 23-1495, Fleming versus Oxford FIRE-EMS, and 24-773, Casey Fleming and others versus Town of Oxford by and through its Board of Health. Two of the pro se appellants in each case, the same two, are present to argue. I take it that we will not be hearing an argument from the third appellant, assuming there is still a third appellant.
That's right, yes.
All right, and we are going to hear first from Mr. Fleming. You are not an attorney, or are you?
I'm not.
Okay.
So I'm only representing myself.
And they're nice briefs for non-attorney written briefs, if indeed they are non-attorney written briefs.
Thank you.
Which is part of why I ask. All right, so we will hear first from Mr. Fleming, and maybe if you could start with the mootness question that hangs over both of these cases, that would be helpful to us.
Thank you. Casey Fleming, good afternoon. So the active interest is our tort case. These inevitably will be brought up in those cases, so that's an active personal interest, so I think that.
But let me ask you this. We wouldn't be saying those cases are moot. Those are damages actions, which, at least in my view, although it's up to the court itself that's hearing it to decide, those cases aren't moot, I wouldn't think, because you're talking about damages that you suffered already as a result of this conduct, and that would be a place to litigate whether the conduct was unlawful and then what the damages are, at least as I understand it. Is there some reason that is not adequate, and you know what I mean, and somehow that case beyond that keeps this one alive?
Well, so there's case law that says federal court can't overturn what a state court did. So where you have the state court trial judge said this is allowable as a matter of law.
Well, my sense is, and I'd have to look into this, when cases are moot, I think under a doctrine, the federal doctrine is called Munsingware, I think we vacate the decision below because the case is moot, was never appealed. And it may be that town council knows more about this than I do. That's just my recollection.
I don't know the answer to that one, sorry.
Okay.
All I know is that it's inevitably going to be brought up in the federal case. So while that's not the case before you, it's still an active personal interest. So I just think that the outcome of this case is inevitably going to be brought up in that case unless you say this is moot and therefore we vacate this decision on the basis of mootness, then there's no decision to refer to.
So on that issue of mootness, if I can ask, and I mean, even for practicing attorneys, sometimes all of these terms, at least I'll speak for myself, you know, mootness and res judicata and standing and all these different, you know, legal terms can get a little bit messy, right? But on the issue of mootness, I just want to make sure that there's no dispute you sold the property.
Yes.
Okay. And on the 1495, it seemed to me your argument was that the second order by the town of Oxford that kind of put in the right language, or the more correct language, if you will, about the use of those, not extension cords, but the portable
RPTs.
RPTs, never heard of that, right? You were arguing that, and are arguing that they can't do that. That's unenforceable because they had their bite at the apple. And you went through the Fire Board of Health and you won, right?
Yes.
I understand that. So the doctrine of mootness, while you have a personal stake in not being wronged, everybody does, right? By a system or an entity or a person. We couldn't give you a remedy because we couldn't say, okay, you're right, just assuming, and now we're going to order that the second order can't be enforced because it, in layman's terms or layperson's terms, it doesn't matter anymore because you don't own the property. See what I'm saying?
And presumably you took all your RPTs with you.
Yes.
Right,
Yes.
so.
No, you are right that this case on its own, you're right. It's just, we don't own the property anymore. I agree with that.
So, but as it's related to the claim, so it's, you know, it's like the hitch, right? We couldn't provide you with any relief in the sense of, we don't just order things like, oh, don't enforce that second order because there is no more home that has this issue, owned by you.
I mean, so the order is not enforceable no matter what, because we don't own the
'Cause you don't
property.
own
I
it.
agree
Right,
with that.
right, so-
We did ask for costs and fees on remand, so there's that.
There is that, although I will say only because, and it's not because I have any magic, ability. I had a case similar, not really, but the issue of attorney's fees. It seems like the case law out there on discretionary fees says standing alone attorney's fees aren't enough, in essence, to breathe life back into a mootness argument.
That's true. It's not the best argument, so.
But it doesn't mean you weren't wronged or that what you went through. I'm just trying to focus on the legal doctrine of mootness with you selling the property while this case is on appeal. And I'm looking at it from all different aspects, and I'm trying to understand what's your strongest argument of why it's not moot.
I have three. Well, first,
Yep.
I do think it's going to be brought up, and it's going to be argued about inevitably in the federal case, so I don't want to create a circular issue where, oh, this was decided in state court, so now it's fixed in place, but the only reason it wasn't changed is because it was moot. If you're arguing about it, it's not really moot anymore. There's still an active personal issue.
Okay.
Or personal interest. It's been fully briefed, so the custom is where it's been fully briefed, and the motion to moot was very soon.
Number 2?
Yes, sorry, number 2. The motion to moot it was almost right before oral arguments. Generally, they are decided. You don't have to, but there's no constitutional question, so usually they get decided. And number 3, respectfully, the reason we moved out of the state is because of decisions like this, where you have the judge says they abandoned the order, and on the basis of abandoning it after losing, that's not waiver, and they get to not abandon it by just bringing it all over again. That's crazy.
But that could be part of your damages in the federal suit. I mean, I don't know if it could or couldn't. I don't know what your complaint says. I haven't looked at that, and I don't know what you're asking for. But
yeah.
all of your, I assume you're allegedly injured in lots of different ways by the whole course of conduct of the town in its dispute
Yes.
with you, which appears, I mean, I have no idea, but appears to all be sort of rolled up into one thing, which I gather is the sale of bearded dragons from your garage.
Mm-hmm. So where this relates to that, it's you lost, you didn't appeal, you clearly can't just continue to try to enforce the same thing all over again. That is part of the course of conduct, so that's how the two cases relate to each other.
Assuming it's not moot, I have a couple of questions. Oh, and for the second case, the Board of Health case, same arguments except no attorney's fees are sought, right? That's as moot
I think
as
we
the-
actually did ask for that in the complaint, but, I mean, there haven't even been any motions that they were actually part of the case for, so.
But it is equally moot because regardless of service of process and why all of these things did or didn't happen, it doesn't matter because it's not your house anymore, so there's no orders affecting you.
Yeah, so that one didn't get a decision on the merits of it, so I think it's more moot than the fire cases for that reason.
All right, can I ask you, assuming it isn't moot, I just have a couple questions about res judicata. And as I say, I usually say to pro se litigants, like, it's scary to come before a judge and you know what I mean, and we're going to give you leeway, and we are going to do all of that. But you're doing a remarkable job for a non-lawyer on all of this, both this argument and your briefs. But let me ask you this. I understand how res judicata works if there's a proceeding of some kind. But I'm trying to figure out, just as a matter of, let's call it common sense. I understand if someone brings a suit against someone and goes through all the rigmarole of the suit and doesn't raise the argument that it was also a breach of contract or something, why we say to that litigant, listen, you've wasted our time, you've wasted their time, right, you should have brought it all at once, you didn't, and so thanks for playing, and we're done. In this case, an order to correct conditions is about a violation of a particular section. I might have something in my house that violates 4 different sections, and the town thinking, well, the really important thing here is these extension cords, just hands me an order and says it's extension cords. And I might look and say, these aren't extension cords, and I have to go and appeal, and I win. But there might be something else that's actually, whatever it is they're talking about, might be a safety concern. You know, it's not just some past thing. It's an ongoing safety concern. You know, we didn't cite them for the oily rags, and we really should have done that too, but we didn't. But they're there. We inspected and saw them. Why shouldn't the town be able to say, and I know they were talking about the same cords here, but why shouldn't they be able to say, oh, by the way, there's another dangerous thing in the house, if these are by hypothesis dangerous, which I'm not saying they were or they weren't. How can it be that the fire department can no longer go in because they saw the condition one time and didn't write a comprehensive order?
Because they weren't the ones to decide the case. So all of the claims before and now are all fire code claims. The
Yes.
fire board has jurisdiction over that. So they say in the new order, this is based on the same, it's the same objects,
Yeah.
the same inspection, and they say based on the evidence at the hearing. So if you go with what they're saying, there was evidence of numerous imminent safety hazards at the hearing, and the tribunal that had authority to decide it didn't say one word about it in the decision.
Well, here's what they did say.
Why didn't they have to appeal
They
that?
said, these aren't extension cords, they're RPTs. This is an inapplicable section. Right, that's what the board said.
Yeah, I will point out, he is still calling them extension cords in the new order.
Okay. But that's what the court said. Now, if I'm the fire department, the reason I don't appeal that might not be, oh, I want to introduce, there would be no way in that appeal to say, oh, I cited the wrong section in the order. Let's say they agree, I cited the wrong section in the order. These are RPTs.
But it did all come into the hearing. So why aren't they required?
Well, because presumably the order doesn't mention the section about RPTs. So I'm trying to figure out if they had wanted to change it. Oh, we said extension cords, we're idiots, but there are still these dangers, they just happen to be RPTs. I don't see how continuing the proceeding after losing on appeal would have allowed them to amend their original order, because that's not what you do on appeal. You don't amend the order, you review it.
Well, the decision says, its final conclusion, it says basically, well, there was all these other claims made. They weren't properly before us. It was before them. It just wasn't in the order. So we don't decide it. They could have filed, and I'm not saying this would have had merit, but they could have filed a complaint saying, under Chapter 30A, it did come into the hearing. The record shows all this stuff was argued.
It may not matter, and I don't know enough about administrative law to know, and I will ask opposing counsel. But maybe they can't do that because they've got a written order, and all they can do is defend what they wrote, and it's not defensible because it says extension cords. Surely there must be some way if a fire department makes a mistake, and I'm not saying it's a valid argument anyway, but if they make the kind of mistake where it's like there aren't any extension cords there, there's only RPTs, there must be a way for them to correct it after the board points out you've cited the wrong thing. And I just am not sure why the right way to do that isn't then issue a new citation that has the right thing. I understand it was raised, but I don't think the board could necessarily affirm it on the ground that it said one thing, but it meant another. I mean, I'd object to that if someone did that to me and said, what do you mean? You send me this notice that says extension cords, I do all of this, and now you're going to tell me on appeal? I don't have a citation for RPTs. And
well, I think the argument that they're making effectively boils down to this evidence came into the hearing. The evidence showed various imminent safety hazards within that tribunal's authority. They didn't find any safety hazards. That would be an appeal. If there was evidence in it, why couldn't they file an appeal and saying, Your Honor, we should have won on this?
Because there was
The
no evidence of
supports it."
extension cords. There might have been evidence of a different kind of safety violation, but they might have thought, well, we'll just lose on appeal. These aren't, now that we look, they really aren't extension.
Well, so let's say they're right. Let's say imminent safety hazards, all kinds of evidence. It's within that tribunal's authority. Why isn't the appeal, Your Honor, clearly this is wrong. This was an abuse of discretion. It's an error. This is within their authority. They should have ruled with
wouldn't the court
us.
say, it isn't wrong, you wrote extension cords? That's a question of fact. These are not extension cords.
But the record of the hearing shows, it didn't just kind of get mentioned in passing. He filed hundreds and hundreds of
Well, I
pages
get that,
of
and I know
all
that you have
sorts of nonsense.
you have a suit in the federal court about lots of that stuff. I'm just trying to figure this out. All right, your time has well expired, but maybe there's more on that? No? So we will hear now from Mr. King.
Do you want me to talk about the second case?
Oh.
Or did you want to? I mean, a lot of it's the same thing. He's just taking extension cords, literally the same
this is a little
claims
bit
and moving
different
them somewhere
because
else.
it's about the attorney's incredible lack of diligence and whether it's essentially whether it's an abuse of discretion to force you to be bound by that and presumably go file a malpractice action against your lawyer instead of, renewing this. I mean, you're not a lawyer, but I guess I'll ask, why can't a judge say, yeah, I could reopen this because your lawyer did such a jerky, terrible job, but I don't have to, it's discretionary. And sometimes usually we say you're bound by what your lawyer did, and you're bound by what your lawyer did, and go sue them. How can that be an abuse of discretion?
Well, I think in this case, what you have here is our lawyer effectively held the case hostage. I'm contacting her on nearly a daily basis.
I understand that. And so you could sue the lawyer for malpractice. I mean, I think that might be your remedy if you have the worst lawyer ever and they've done something that's damaged your rights, is sue the lawyer.
But that doesn't reopen this case.
I agree with that. But what I'm saying is, since that's an avenue available to you, how can it be an abuse of discretion for a court to say, well, your lawyer did all this? I mean, I hear what you're saying, and maybe it's true, but...
The judge's decision doesn't address the case law on pages 25 and 26 of my brief, the McIsaac and the Tibbetts cases that effectively say, if your lawyer is negligent, but it's not the lawyer's case, it's my case, and I'm not being negligent, I'm being diligent, that should separate the two.
It's one of the Berube factors.
It is, but those cases say...
It's not all of the Berube factors, it's just one of them.
They do say the lawyer, I agree, no one's saying that the negligence was excusable. And so that's part of the problem with the decision. He says, well, it's not excusable neglect. The motion's not premised on excusable neglect. It is premised on it very much not being excusable. It is that what I did to get her out of the case, to try to get the case moving, that was not neglectful. I wasn't neglectful. So that should be separated, and the judge should enter a decision that addresses why is what I did not enough to bring this case back. Because I don't know what else I could have done. I mean, I have in my affidavit, and he doesn't say anything to say he doesn't credit this as true, that just the times I contacted her in writing was 29 times. I couldn't have done more than what I did. And then you have the second phase of this case, which is I finally get her out of it, and then the clerks say you can't have a summons till you get the 60B motion granted, and then the 60B motion is denied for not having a summons. You can't have both of those things be true. Only one of those
What's
can be
the
true.
evidence of the first thing, that you tried to buy one on March 23rd? I didn't see in the affidavit that it actually said you tried to pay for a summons and they wouldn't give it to you.
I think that I included I thought I included an affidavit about it.
Hold on.
Well, so for one thing, they didn't write anything in the record about the first time that I tried to buy it, but then in the docket on November 20th, 2023, after I had made another request, finally gotten the summonses, served them, and then turned them in.
I'm aware
and mailed
of
them back
that.
to me.
That's in November. I'm talking about March 23rd because that's before you filed the 60B motion. Like that I could see maybe might have made a difference. November is is after it's all
Right.
over. Is there evidence that on March 23rd you asked for, I mean, I looked at least an affidavit of yours and I didn't see it, but maybe I'm looking in
The issue
wrong-
was argued, I don't remember if there was an affidavit with it, but it was argued in my motion for an order directed to the clerks to make them accept my summonses.
The return of
for filing.
service.
Yes.
Let me hold on, let me.
I mean, the judge doesn't say anything about not crediting it as true, and I think that this docket entry shows this is the policy of the clerk's office, that they do think they're not supposed to be giving out summonses or accepting them until the case is reopened, which is not right. And I didn't.
Looking at your record appendix at 75, paragraph 11, but I'm not sure, that's paragraph 10 and 11 on February 7th, 2023, and on March 3rd, 2023.
Well, I see March 23rd in paragraph 14, but all it says is I contacted the clerk's office to see if they had
11.
the proof of service.
So when that was filed with my Rule 60B motion, I didn't go into detail about how they had denied me because it requires that I have to be aware that the judge and the clerk are not, that the judge doesn't know what the clerks are doing. My assumption is the judge knows what the clerks of the same courthouse is doing. I have to know the left hand is not aware of what the right hand is doing. My assumption is if this is the policy of your courthouse, I assume all the staff know about it. So when I got this decision saying, well, this is denied for no summons, to me it was very shocking. So then I brought this to the judge's attention in my motion for the order directed to the clerk's office, and I've appealed that as not reconsidering the previous decision.
Okay. All right, we will hear now from Mr. King.
Thank you.
Good afternoon, Your Honors. Starting with the appeal, the fire decision. I think, what I'd like to kind of draw the court's attention to is, Justice Rubin, you mentioned common sense. So we got 3 fire orders here about, we can call them RPTs, what normal people call them are power strips. And so what I'd ask this court to consider is, do you really believe that a fire chief with decades of experience doesn't know what a power strip is? That it was just an accident? It was not an accident. And if I may step outside the record for a moment, as an elected official in the town of Oxford, this case was used on the floor of town meeting to argue against why residents of the town should not listen to me when I'm advocating for extra funding for teachers. So this is not like some casual sort of oops. I'd like to draw the court's attention to the fact that this motion for mootness only occurred after we sold the property, because the real objective here was to run us out of the town, which, congratulations, they succeeded. This same council was at the property in October, well aware that all of the conditions associated with this fire order were long gone. There was no motion for mootness then. What was essential was that we were driven out of the town. And on the day that happened, now we can say it's moot. Now the objective has been accomplished. To Justice Rubin's point about, well, what is the fire department to do if they make an honest mistake? Well, we've been in a unique position to split test virtually all of these decisions, where when we're on the side, one side and the town is on the other, and then you can reverse the positions and see the outcome. We know from our litigation that Dudley District Court will give out an administrative warrant for virtually anything. Just ask, and you'll get it. And so if the fire department really believed that there was an actual imminent safety hazard, does this court really believe that a judge at Dudley District Court would not grant an administrative search warrant to come back and verify the conditions at the property and, if necessary, write a new order about that? What this decision allows for is for a chief to just sit behind his desk writing orders. I mean, it's remarkable to me he only wrote just these 3. He could have written another dozen. And each one, we would have had the burden of appealing.
Can you explain, the first thing you said was that it wasn't a mistake that it said extension cords when the chief knew they were power strips. How does the chief or the town benefit from writing an order that gets reversed on appeal?
What I would say, Your Honor, is that they made every argument. This was not an order that was written in the public interest to provide safety. It was a fishing expedition to find something. And if
but you said he saw this, knew they were power strips, but wrote extension cords. Now, if what he'd found was power strips and he thought he could win, you know, getting you to have to take out the power strips, presumably to shut down the breeding operation, I suppose. I don't really know enough about heat lamps or reptiles or to have any idea. But I assume that's sort of what this is about. I don't understand how miswriting the thing so that it was wrong
May I clarify,
is helpful.
Your Honor?
Yeah, please.
So, unfortunately, this court is probably not in a position to understand the technical details of the fire code. But if you look at the requirements for power strips, they're less stringent than for things like multi-plug adapters and extension cords because RPTs have a surge interlock in them, where if you draw too much current, they pop open, they interrupt the current. An extension cord doesn't have that. Where you see fires is where people use the little 2-conductor extension cords to overload them.
Even if I accept everything that you're saying as true, that this was a orchestrated plan by the town to kind of run you out of town, right? And that they used every trick in the book, okay? And just for a moment, I agree with everything. When you don't have an interest in the property, it doesn't mean that what the other side did was right.
May I speak to that, Your
right?
Honor?
I do want you to speak to it because that's my problem. It's not that I'm then saying, oh, okay, well, no, even though we should address this because of the terrible reasons why the town did this. It's you don't have a stake in the outcome. Now, on damages, sure. On lost property value, sure. On a bunch of other theories of recovery that I think are pending, absolutely maybe, you know. But
So
to
answer Your Honor's question, so this isn't hypothetical. Our federal case has already stayed waiting for the outcome of the zoning decision. And in that request to stay, the appellee basically highlighted all these other cases, that these are reasons to stay, and oh, when it's our case, well, these all have to be stayed, it can't move forward. And you'll hear, when we pivot into the health case, kind of the opposite of that. So these, as Appellant Fleming said, we already know that they're going to bring these up and they're going to say, well, you know, this wasn't legitimate, and see here, they got this fire order and it wasn't legitimate, and the court agreed that it wasn't legitimate, and they just mooted it. And that's our stake. And then additionally, as Mr. Fleming attempted to articulate, there is a public interest here. This case is not a secret in the town of Oxford. I was elected to office with the full knowledge of the public of these cases. Other people told me they wouldn't run for office in the town of Oxford because they wouldn't have done to their family and done to their family and their business what was done to us. And so then the question I say to this court is, if the town can do these sorts of things and just get away with it.
No, but I think what Justice Walsh is saying is you have a federal case about that. This case is actually about whether you can have these RPTs in your house, the RPT cases, and you don't have them anymore, so there's nothing for us to fix. In this case, I'm not saying that, just as she did, I'm not saying you're not aggrieved. I'm not even saying you're wrong. I don't have any idea. The facts should be determined in a trial. But
May I briefly address that?
But the fire one and the health one, if you don't own the house, there's nothing for us to do to, even if we agreed with you, to help you.
And so, Your Honor, what I would say to that is that what this case actually was to an injunction to prevent the town from bringing more orders. So now, what I would say is, hypothetically, if we were to come back into Oxford in some way, having the injunction, like, look, this decision was final, you can't bring this up anymore. You know, that's what we're really here to defend, is the principle that 30A means something. That if you as an appellant file a 30A appeal, it is possible to win. Because if you, in this circumstance,
Well,
if you
people
win,
win
it doesn't matter.
people win 30A appeals before us all the time.
Before you. And we're coming to you today because at the lower court, the decision we got said, well, it doesn't really matter if you win because they can just bring the same issue again and you could win that one and they can bring it again. And eventually, if they bring it enough times, maybe they win once, you know, and it's just, there's a concern about the rule of law here. It doesn't mean anything to prevail on a 30A appeal, or should people just accept, it's like we're under the king. Well, the town said this and you just have to live with it. So I see my time's expired. Are there any questions on this or should I proceed to the health case?
Well, go ahead.
I mean, I understand your argument about the difference between the relocatable power tap and an extension cord and why you seem puzzled how a fire chief could get that wrong. But let's say that they did get it wrong. Is your position then that the town can never come back and?
No, Your Honor, as I said, if the town really believed that there was seriously an imminent fire risk there, they could have come back to the property, done another inspection. We wouldn't have supported that. We wouldn't have agreed to that, but I guarantee you they would have gotten an administrative warrant even if we said no.
They got an administrative warrant the first time, is that right?
Not for this particular inspection, but the original one. So we have a sequence of there's the 2021 inspection,
Okay.
then there's the 2022 inspection.
Which is the one that you were cited for 2022?
Yes.
I see. So you let them in for that. They didn't get an administrative warrant.
They were provided discovery access as part of the zoning.
But presumably, knowing what they know from that inspection, they could go in and get an administrative warrant. Say there's probable cause to believe, see these photos, there's probable cause to believe that these RPTs are still there. We'd like to go in and inspect and make sure that they're not there. They go in, they see them, and then they could, in fact, have written a new order.
And I would posit, Your Honor, that that's not an incredible burden for the government to ask for just the minimum level.
No, I see what you're saying.
Of having to even go before a court and say, hey, we think there's a problem, or can he just sit in his office all day long just writing orders, writing orders, writing orders?
Okay, your time on this has expired. If you'd like to talk about the health case, you may do so.
Thank you, Your Honor. One thing I'd like to draw the court's attention to on this matter is that it may be a little unclear from the record. There's a lot in the record, obviously. This occurred at the exact same time that this is going on. There's all these other cases, all this parallel litigation going on about the same issues. So at the same time that, you know, this case, approximately, that this case is being rejected by the court, our attorney is also abandoning us on the zoning case. And we had to get an order from the appeals court to direct our attorney to...
It's a different attorney or the same one who didn't do all the health stuff?
It's the same attorney, Your Honor. Okay, so the attorney...
But why isn't your remedy to sue her?
Because
it's malpractice.
We've already been driven out of the town, Your Honor. Like, it's, you know, in that sense, coming after the attorney...
Okay, but I assume the reason... I shouldn't assume. This court affirmed the zoning decision. So presumably that's what actually caused you to leave town, not...
What I would say, Your Honor, was the fact that there's no yes for an answer with this town. Even after the animals were removed, even after, you know, we had ceased operations of the business, the town continues to pursue us. So, you know, in that sense, there's no getting yes for an
but
answer.
the zoning violation was for breeding the animals and having the turtles.
Yes.
And you're saying you got rid of them, and if you got rid of them, then it's a residential house in a residential zone, isn't it?
So this is getting outside of the record of this case, but so we had ceased the business, we had rehomed the majority of the animals, and the town continued to pursue the zoning violation. So even
because there were still some turtles in the basement, kind of thing, or why?
Because not every last animal had been removed, and they alleged with no evidence that the business was still operating.
I see.
So even when there was no evidence the business was operating, we stated the business wasn't operating. Even as I don't know if I said this before, but so again, this comes back to the motion, you know, to dismiss it based on mootness. Again, they knew in October that the business was gone, the animals were all gone. They weren't asking this court to dismiss it then. You know, so these cases are just weaponized to drive us out of the town. But where I wanted to go with this was to say that, you know, in that context of our attorney is abandoning a case, the court is refusing to allow us to file motions because the attorney hasn't withdrawn. You know, for this case, I would ask this court to consider, like, how many flaming hoops of fire do we need to jump through when our attorney is just refusing to do anything?
But we're not responsible for your attorney. Our oversight is of a government agency, lower courts, but your attorney being outrageously negligent isn't, you know, that's not our...
And so our argument, Your Honor, in this particular case was to say that at the time the judge made that decision, the judge was not aware of the fact that our attorney hadn't done this stuff. All, as far as we can tell, the judge based it on was, well, I haven't seen anything in this docket move, so I'm going to dismiss this case. And then when we, you know, and then he cited to the amount of time that had elapsed. Well, then more time elapses because we can't get things filed, because we can't get the attorney to withdraw. And then the response of the judge in the ruling is not to say, well, after looking at, you know, everything you've said in your affidavit, you know, I still don't feel like, I feel like you could have done something more. The response is to say, well, even more time has elapsed. Well, of course, you know, that's what we were trying to say. And so it's where we say we think it's an abuse of discretion, it's because we're looking at that going, well, but we made this motion. It doesn't appear like you actually considered anything in the motion. All you're saying is, well, more time has elapsed. It's now been a year. Well, because we can't get the summonses. And then when we get them, we can't get them to accept them. And so this is why we come to this court on this issue, is because it just seems like there's just no way for a regular person to just like get the process to move. You know, where the opposing counsel in the brief makes a lot of references to, oh, well, they didn't do anything until November. What we actually said was that was what we had in writing. There were many phone calls, but we didn't feel comfortable making an affidavit with representations of the court unless we had it like, oh, we have it in writing. Similarly with the filing of the summonses, you know, we wanted it to have in writing. We wanted to get the affidavit from our attorney to show the court, look, this is what the attorney is saying. You know, because if we just went into the court and just said a bunch of things, you know, the judge is going to believe us. You know, and that's kind of what I leave for this court. I see my time's expired. Are there questions?
Can I just ask, you're an educator?
I'm sorry?
You're an educator, you're a school teacher?
No, I'm a nuclear electronics technician in R&D.
Did you say something for the town of Oxford that you are in some capacity?
I'm a selectman in the town of Oxford.
Okay. Regardless of the outcome of this particular case or cases, which I honestly don't know what it will be, I will say that to whomever contributed to the writing of this pro se appellate brief, it was one of the best ones I've ever seen.
Thank you, Your Honor.
Excellent work. And pro se, it's very impressive. All right, your time has expired. We will hear now from Attorney Smerridge.
Good afternoon, members of the panel, and may it please the court. Roger Smerridge on behalf of the appellee, Town of Oxford. I'll jump right into the mootness in a second, but I just want to clarify a couple of things. One is that the two dismissals here were not on the merits, so-called. They were procedural dismissals. In the FIRE case, it was for failure to exhaust administrative remedies. In the BOH case, it was for the service issues. So to say that there are decisions on the merits from the underlying courts is not correct. With respect to the mootness, the SJC rejected the very argument that other pending litigation somehow keeps a moot case alive in the City of Lynn versus Morrell case that is cited in our motion.
But what about their argument you basically ran them out of town, that we can't expect them to keep putting up with this and you've accomplished your goal? That can't possibly be, then that moots the case.
Well, with all due respect, Your Honor, I think a lot of what was said in that argument goes beyond the scope of the record in this case. What is...
Well, but what's not beyond the scope of the record is, I mean, I do not have a background in fire science, but, a quick look at the definitions of these things is RPT is different from an extension cord, and also a little tiny bit concerning that most people in the Commonwealth are probably violating the rules you don't like, because none of us have enough power. I mean, I don't know, I got out of the landlord business when I took this job because it's hard to comply with our tenant-landlord laws. But I mean, I went over, I was in the business for 25 years, and in the 25th year, I go over, everyone has their own electric toothbrush, everyone's charging their own phone, everyone had their own coffee bean grinder, because God forbid we just have like regular coffee. Like the needs of electronics of young people today are just, I can't even comprehend them. So if the way to go in and bug somebody is to say you've got these, what I would call a power strip versus an extension cord, like, it's alarming, because the government could just really destroy anyone they wanted to destroy.
Again, with all due respect, I don't think anyone was intending to destroy anyone here. The fire code is what it is.
How do you mix these up? How do you mix up an extension cord and a power strip?
The thing is that question should have been put back to the FPRAB, and that's what the underlying decision is at issue here in the FIRE-EMS case, is that these plaintiffs, when they wanted to challenge that second order, should have gone back to the FPRAB. Chapter 22D, Section 5 is very clear on that. When you want to challenge a local fire code enforcement order, you have to go to the FPRAB first, and they
Your
didn't do so
position
here.
is that it's not res judicata. Why don't you have to do a new inspection?
Because
you do an inspection, you write an order, the order is found invalid. Thanks for coming in. There may still be other violations there. There may be a pile of oily rags that you didn't see in the basement.
Sure.
You have photographs. They apparently show our PTs apparently in violation of something. That was a while ago, and you already issued a citation for that. Why don't you go get an administrative warrant and look at the place?
And if they wanted to raise that issue before the FPRAB, they could. And
Well,
if the
of course, now
FPRAB
the
disagreed with
actual
them,
question, though, is can the FPRAB hear that? You say they can. They say they can't. How do we figure that out? I know some boards certainly can.
I would say you look at the statute, Your Honor, look at Chapter 22D, and if they don't like what the FPRAB says on that issue, then they have their rights under 30A to appeal the FPRAB's decision.
What if the FPRAB correctly concludes our statute doesn't permit us to determine that we don't have jurisdiction on res judicata grounds?
Then they can come into court.
Well, actually, that's the question they're asking us right now.
And Gill is very clear. You have to give the agency that opportunity in the first instance unless there is a clear lack of authority. For example, if the FPRAB was trying to exercise jurisdiction over the sanitary code rather than the fire code, that would be a clear lack of authority. And in that case, you could go around.
There has to be a lack of authority. Calling it a clear lack of authority doesn't get us much of anywhere. The statute either has to allow it or it doesn't. And I don't know if the statute in this case allows this board.
Well, but I think that's why the language of the case law is a clear lack of authority, because if there's a question of authority or jurisdiction, the administrative agency is entitled to decide that in the first instance. They may get it wrong. And if they get it wrong, then the appellant has their rights under Chapter 30A to have a Superior Court judge say the administrative agency got it wrong and actually did not have jurisdiction. But where it's not a clear lack of jurisdiction, you have to go to the administrative agency in the first place and give them that opportunity. And I think Gill and Wachewski are clear on that.
I think I interrupted you answering my earlier question about why not just go get an administrative warrant and do a new inspection.
Yes. Your Honor, the case law on estoppel against municipalities.
It's not estoppel.
Well, it would be a form of estoppel.
Might be. Or it might be res judicata, right? It might be claim preclusion. That's not, it's like an estoppel, but it's not estoppel.
But principles of estoppel.
It's not it's a principle of adjudication. I don't know if it's a...
Well, and again, this is why I think these issues may be getting a little muddled. The issue of res judicata, again, see what the administrative agency says on that. FPRB may agree. You know, the appellants here never gave give the board the chance to make that call. And that's what,
I
that is
assume
why
you
this
argued
report-
below not merely that exhaustion was required, but that if it wasn't, you win, I assume. Is that what you argued below, or no?
Yes, that's why the case was dismissed, because they didn't exhaust.
Okay, but
But
did
they
you
did.
also, so what was your argument for why you're allowed to do it? Just, no estoppel against the government?
I'm sorry, could you say that again, Justice Rubin?
I assume you had an alternative argument in case you lost on exhaustion.
No, we won on exhaustion. The case was dismissed on exhaustion.
I'm saying you must have argued something to them. Well, you do to us in any event, right? If exhaustion isn't required, you still think you win, right?
Well,
because no estoppel against the government.
We win on the merits of the fire
Yes.
code issue?
On the merits of res judicata.
Yes.
You think you win on that, right?
Yes.
But the reason is no estoppel against the government.
Correct.
Okay.
So, returning to the issue of mootness, the other argument that has been advanced as to why these appeals aren't moot is some semblance of public significance and confidence in the judicial system. And the case that the appellants have cited on the public significance doctrine is Doe versus Police Commissioner of Boston. In that case, the issue was one of constitutionality of a newly enacted statute. And as the SJC explained in Commonwealth versus McCulloch, 450 Mass 483, the typical application of that exception to the mootness doctrine is where there is some uncertainty regarding a rule or a statute, and that's not the case here. These are, as I said, procedural dismissals.
Well, if the town of Oxford is going around issuing multiple citations from a single inspection, and after they lose one, issuing another, and so on, that might be an issue of public importance.
With all due respect, there is no evidence in the record that there was any orders issued beyond the single property at issue in this case. And that property has now been sold, and the town, once the property was sold, brought the motion to dismiss it. The reason why it didn't ask the court to moot the case earlier was because the property hadn't been sold, and the town...
Did you go in and make sure all the RTPs or RP, the power strips were taken?
The last time a town inspector was in the property, there was still electrical equipment in the garage. So that inspection occurred in October of 2024. That was the zoning enforcement officer. And again, we're going a little bit beyond the record, but I'm happy to indulge here. That was a compliance inspection that resulted from a Superior Court injunction in the town's zoning enforcement action.
But the town was unhappy because it was just sitting in boxes in the garage?
I'm sorry, could you say that again, Your Honor?
The town was not happy with them because the equipment was sitting in boxes in the garage but not in use?
It was
still attached.
It was still attached.
So maybe this isn't moot.
Okay.
I'm sorry, Justice.
Maybe it's not moot. Maybe it's still plugged in the garage.
But these appellants don't own the property anymore. So if the town has an issue with that, it needs to bring an order against the new property owners. Excuse me, Justice Walsh?
Bring an order against the new property owners, just wondering.
Not as of yet. Again, these are very recent developments. The property only sold less than a month ago.
So,
And do they have to bring a new one? Could the new owners be substituted for these litigants?
I don't believe that the order to enforce
runs against
the
property.
I don't believe so. I believe it's personal.
Okay.
So they're arguing, well, this is all fully briefed, and frankly, most people don't seem to have the fight that these folks have. And so we should just decide it. Why are they wrong about that?
Because there is no relief that this court or the Superior Court can any longer grant to these appellants.
Well,
they
I
don't
think
own the
they're
property.
wanting us to say that you were bad, and that we can still do that. And that would make them very happy.
With all due respect, I don't think it's the province of this court to say whether a party is good or bad. It's to decide legal questions.
You violated the laws, or that you violated the law, or you didn't play fair. That's what they want.
But again, the underlying dismissals was not whether the town played fair or was good or bad. The underlying dismissals was, in the FIRE-EMS case, did they exhaust their administrative remedies? And in the BOH case, it's did they timely effect service? And the answer in both cases is no.
Well, in the health case, it's should the 60B motion have been granted or reconsidered, right? It's not, did they serve on time? They clearly didn't serve on time. The issue is, given that it was their lawyer's fault, according to these affidavits and so on, should it have been reopened? And in particular, I mean, the part that interests me about it is, if they wouldn't give them a summons.
If they wouldn't give them the summons, whether it was in March 2023 or October 2023,
well, that makes
it doesn't matter. The service window is already closed.
If I go into a judge and I bring a 60B motion and I say, Your Honor, my lawyer, here's my affidavit of the 29 times I called her, and we were really relying on her, and it turns out that was misguided. And so the first day we could, March 23rd, we went into the clerk's office and got summonses, and we've served them now. That's a better 60B than maybe one day we'll serve them.
It may or may not be, but it's not this court's job to substitute the judgment of the trial court.
He's arguing that the judge did the wrong thing, that the judge didn't separate him from his attorney.
But there was reason in the record not to, and the affidavit that is in the record does say, we contacted our attorney the day after the service window closed. There's nothing in the record to show that the appellants themselves did anything during the service window to prompt their counsel.
Okay,
so
why would they do that? I mean, I hire a lawyer. I hope the lawyer's really good. The town has hired you. They hope you're really good. They're not calling you every time something's due to make sure you filed it. That's what you do.
But if there's a service deadline,
they still aren't calling you. They assume you did it because you're a lawyer.
And if they didn't, then the lawyer should have asked for an extension of the service window. She didn't. And the Berube factors are very clear that the diligence of the party themselves factor, the last of the Berube factors, is the court takes it with caution. So it may be, and under the Byrd case.
Once this case got dismissed, they couldn't just rebring it? Like there was like they had one shot, is that it? You know?
Well, it was a certiorari review case, and by the time...
Oh, it's 60 days.
It's the 60 days.
But the statute had run.
That's a key issue here because the policy behind that statute is for reasonable contemporaneous review of these decisions. You can't wait a year and say, oops, there was a mistake.
Don't you kind of wish the judge had gone through the Berube factors and figured this out?
I don't think it's necessary because when this court looks at them, not many of them, if any, favor the appellants. But the judge's endorsement on the motion is right below the recitation of the Berube factors. It's not like the judge disregarded them. But the case law post-Berube, and Byrd versus Ross in particular, makes clear that just because the facts that were present in Berube supported the judge's decision there, doesn't mean that that dictates the outcome, because again...
Well, it's discretionary.
Exactly.
But I'd like to know, how the judge weighed them.
And the results is how you know how the judge weighed them. He denied the motion. So I think that's indication that the judge, in his discretion, thought that the Berube factors did not mandate reopening the case. I see my time is almost up, so if there are no other questions, the town will rest on its briefs.
Thank you very, very much.
Thank you.
Both of your arguments have been very helpful to us. This is a procedurally complex situation, so thank you very much for your assistance. That is the end of our final case for today. So I'd like to thank the court officers. I'd like to thank the court staff for their assistance. And we now stand in recess.